Hey, chat. So today we're watching The Wall. Just kidding. We're going to be doing day 5 of South Carolina versus Meagan Jackson. This is being called the river dumping murder trial or the Coroner Coverup conspiracy, depending on who you ask. Long story short, Meagan Jackson is accused of killing the father of her 4 children, Gregory Rice, and then covering it up after the fact. And it's alleged that her lover, who is also the ex-deputy coroner, either helped her. Well, it's not alleged by the prosecution. The prosecution is satisfied with the ex-lover coroner. He only helped her after the fact. But there might be some wishy-washy story where maybe the ex-coroner, ex-lover played a bigger role. That's still waiting. We're still waiting to see if that comes to fruition. We've got the banner cleared up. It's still the state's case in chief. The star witness has already testified, Christopher Dontell. Already testified. I personally thought it was underwhelming. The defense didn't really do much of a cross-examination. And no spoilers. We're going to see what happens today, even though we're a bit behind. We will get caught up. There's, the lunch breaks and all that. And captions are on. Volume is up. We also, guys, Karen Reed had 3 jury questions. The questions to me signal that the jury is pretty much through their deliberations. They're looking at the last 2 charges, lesser included. And I think we'll have a verdict before this stream ends. So if we get a verdict in the Karen Reed trial, we'll jump over to watch that play out. With that being said, hey to STS, bringing us the coffee or the tea if you're a tea person. Hey to Amanda. Let's see. Yeah, will she or won't she testify, that is. And, I don't think that we'll get that typically speaking, but at the same time, if there was a trial for it, with this defense attorney pairing and some of the facial expressions that Meagan has made, I that's where I would say, maybe I just want to see it. But that's where I would say it might be more likely than usual. But who knows? Jenny, good to see you. Jenny says, hey to everybody. Hey, the cat chat mods. Everyone, good vibes for everyone. I'm slimed in. Heck yeah. STS says, depends if the preacher defense attorney is willing to roll the dice. If we were dealing with normal lawyers, I'd vote no. With this guy, who the Sam Hill knows. And remember, it's ultimately the client's decision whether or not they're going to testify, but I would assume clients in this type of situation, this is a serious situation, heavily rely on the advice and guidance of their attorneys. So if the attorney steers in one direction or another, it could make all the difference. And I'd say this, I think this is such a clean, well-presented, cohesive storyline from the prosecution. I'm not one to normally give applause to prosecutors. I like to look for flaws in the case, and we've poked a few weaknesses. But here I don't see how anybody else could give us evidence at this point that Meagan herself wasn't the shooter, wasn't the one who actually had the intent to kill Gregory Rice, other than Meagan herself. So without her taking the stand, whether we get to the beyond a reasonable doubt standard or not, juries are humans, and I think sometimes they want answers, and if you don't give them one, and you aren't hammering home that beyond a reasonable doubt standard, jury's not going to know how else to deliberate and make a conclusion. So, I don't know. Also, huge thank you so much, STS. STS is here not only bringing the coffee, but 5 gifted subs. So, big thank you to STS. I see Amanda shouting STS out in the chat already. So, big thank you there. And everybody tuning in, we've got Nicole coming in right before we start. And Kay, how she do it? I like the name. Says, hey, cat in chat. Sassy Experience, good to see you. This is literally an hour away from you. South Carolina won't do right for hell. And that's the thing, guys. This is South Carolina. It seems to be a somewhat smaller area. And we've gotten these text messages that talk about pretty insensitive things. And while that might not have a bearing on somebody's guilt or innocence in a matter, jurors still could look at that as character evidence and weigh that heavily in their decision, whether they should or shouldn't, right? And Nana Banana, good to see you. Brooklyn, we are not live. We're going to be doing the 2 times and skipping the lunch break. So, Nana Banana, thanks for being a member for 9 months. Saying K&W, you make it great to be here. Good day. I'm excited. I think this is probably a shorter trial and, you know, might be the last day besides deliberations for this, depending on how they timeline it. And then Tay Biz, thank you for the 10. Guys, Tay Biz went through the entire deposition of Mickey Steins, the sheriff that shot the judge. You know, if you like crazy scenarios, go and check that out. A lot of discussion in that deposition about, oh my God, not necrosis. What is it called? Like your brain can be messed up from things like tick bites. I'm losing the technical term. But as soon as I saw that, because we've heard murmurs of a possible insanity state of mind defense, and that deposition gave us a look into that. So Tay Biz did the honor with his great voice and microphone, reading through that deposition. I'm going to grab the link and drop that to you guys in the chat. Thank you for the love, Tay Biz. And Tay Biz continuing tomorrow. Yeah, California encephalitis. Encephalitis. There we go. So let me get that link for you guys. We'll get this kicked off here from Meagan Jackson.
Anything to say before we run through again?
Your Honor, just as a housekeeping matter, we went over the exhibits with the court order. 99A through J, she does not have specifically admitted, but she does show that Your Honor allowed us to publish them, so I would just ask that they be formally admitted. This was where we had 99A through J and 99A2 through J2. It would have been during Lieutenant Wells' testimony on Friday.
I've got 99 got admitted into evidence over defendant's objection, 99A2 and 99J2 admitted into evidence without objection.
So it may have just been that I wasn't there. As I said, in that case, this was, I believe, the HGADE email. And so 99 was the portion of the report that showed the HGADE email. 99A through J would have been the images. Let me just double check that.
Yeah, I don't have 99A through J. I got 99A2 through 99J2.
Right, and so again, I probably just was not clear when I spoke. I handed Lieutenant Wells both 99A through J and 99A2 through 99J2, and we went through them at the same time. So 99A was the IMGDB image from the HGADE email, and then 99A2 was showing that that image had been cached on the defendant's phone prior to the email being sent.
So you're seeking to admit now 99A
through J.
Through J.
Yes, Your Honor. And I believe we did go through them at the bench. Mm-hmm.
And all of this is part of State's Exhibit 99.
Yes, so in 99, Your Honor, you can see smaller versions of the images. So then Lieutenant Wells testified that he went to that image and then was able to show that image on the defendant's phone.
All right, what's the defense position?
Your Honor, we get to them when they were coming in. What does the record show, Your Honor? The record shows right in. Not in.
Okay. All right, I'm going to admit State's Exhibits 99A through 99J. Since State's Exhibits 99 is already admitted into evidence, and these are just a portion of that.
Yes.
You do? Okay.
And then, Your Honor, there's some question as to 62 and 63. The state shows that they were admitted during Detective Edwards' testimony. Those are discs of the surveillance from Lowe's. So it would have been the point of sale surveillance and the parking lot video.
You're whose testimony?
Detective Drew Edwards. I think he would have been Wednesday. He was. I believe he was Wednesday.
You're talking about defense exhibits what?
State's Exhibits 62 and 63.
Yeah, they were never put in. What's the defense position?
It's fine, Your Honor. They're not in this. I don't believe we.
So it was art by identification, never admitted in evidence. What's the defense position?
Whatever the record shows, you know.
All right. State's Exhibits 62 and 63, they want to put in.
That's fine.
The gallery guy is rocking the green sweater vest today. He's back, guys. Facial expressions. These two are acting so incredulous. This guy's bored. He's bored.
Anything from the defense before we bring the jury in?
Nothing from the defense, Your Honor.
All right, let's bring the jury in.
Alrighty, let's get our notebook reminder, notepad. Right in time, factual lie for the notepad reminder.
Ladies and gentlemen, welcome back. Hope everyone had a good weekend. Hope everyone had a good Father's Day. We're ready to resume the trial of this case. Please make sure you have your own notepads and no one else's notepads. State and call your next witness.
Your Honor, at this time the state rests.
All right, ladies and gentlemen, the state has rested their case, and now is the time of the trial where I have to take up some matters of law with the defendant, with the parties, the state and the defense. As I told you earlier, when we discuss the law, it often requires us to reference factual issues, and we don't want you to be influenced by anything that I say or the attorneys say. So I'm going to choose you back to the jury room for just a few minutes, and we'll bring you back out in just a second.
He didn't give an outbound notepad reminder. Alrighty, so that means as far as the jury remembers, we left off with the testimony about, you know, some of the text messages and the images that were sent in that, like, anonymous packet that was dropped off to the Dontell's mailbox by UPS. Oh, so factual lie is going to be the spoiler alert today.
We move for a corrected verdict on the conspiracy charge. Testimony in the case from all witnesses is that there was no agreement between Jackson and Mr. Dontell. Of course, that's required for a conspiracy charge. He testified very forcefully. He knew nothing about it, had nothing to do with it, hadn't agreed to anything. So, under the facts and the law, that charge should be dismissed.
All right, the state's position.
Your Honor, we would ask that you deny the defense motion. In order for a directed verdict to be granted, there must be a failure of competent evidence, and in this case, we believe that there is ample evidence that the defendant and Mr. Dontell acted together. We believe that the conspiracy continued through the disposal of Mr. Rice's body. Certainly, there is evidence that they went to the preserve on the 29th or 30th, and the day that Mr. Rice was murdered, to engage in target practice. There was a text message indicating the defendant, I believe, said, "I'm all for popping a tire now." Mr. Dontell said, "I agree." I believe that's a question for the jury.
So you're saying Mr. Dontell lied on the stand when he said he didn't know anything about it, she jumped out and started shooting?
No, Your Honor. I believe that the way his testimony came across was that he thought she was kidding, and he actually testified at one point. She said, "I hate my kids, I hate my mother, I hate this person, I hate that person." But the conspiracy certainly lasts through putting Mr. Rice's body in the back of the van, storing him at the Myrtle Beach funeral home, and disposing of his body.
No, conspiracy is a pre-arranged plan prior to the act. Disposing of the body is the accessory after the fact. Conspiracy, you have to have a pre-arranged plan between two or more people to commit the crime, and that they actually carry out that crime pursuant to the pre-arranged plan. What evidence do you have that there is a pre-arranged plan between this defendant and anybody else to commit murder?
Your Honor, I would just point to the evidence that I've already highlighted, but I believe it in the court's discretion, certainly.
I'm going to grant the motion as to the conspiracy charge.
There you
I don't
go.
see what the state has presented.
One count gone.
A pre-arranged plan between this defendant and any other person to commit the crime.
Not on the remaining charge of murder, as I understand it, that would be the only charge.
That's correct.
Remains.
That's correct.
We would like to have that dismissed also based on this theory that the liability of Mr. Dontell is so flawed. Either the prosecutors brought out he lied many times. He returned, he said he was afraid he was returning to his relationship with Ms. Jackson. So our position is no reasonable jury could find it was murder here because they would have to believe Dontell.
No way.
And his testimony is so flawed that that wouldn't be a just verdict.
All right, I'm going to deny the motion. I think the fact that he has testified at least creates a jury question as to whether or not he's believable or not, so I'm going to deny that motion. All right, any other motions?
That's all from the defense, Your Honor.
All right, do we want to go ahead and let me question your client on her right to testify?
Yes, sir, Your Honor.
All right, ma'am, if I could get you to stand and raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Your name is Meagan Jackson?
Yes.
All right, Ms. Jackson.
She's waving.
At this time, I'm going to explain to you certain rights that you have. If you do not understand anything I say, please let me know. And if you want me to explain anything in more detail, please let me know. You understand that?
Yes.
All right. We've now reached the stage of the trial where you may present your defense. You have the right to claim the protections given to you by the Fifth Amendment to the Constitution of the United States. This amendment states in part that no person shall be compelled in any criminal case to be a witness against himself. This means that you cannot be required to testify in this case. You have the right to testify on your behalf. However, no one can make you testify. This is a personal right, and no one can waive this right except for you. If you decide to testify, you will be subject to the same rules that govern other witnesses, and you may be questioned and examined and cross-examined on any relevant issue in this case. In addition, if you have any convictions involving dishonesty or false statement or for crimes punishable by imprisonment for more than 1 year, and this court determines that the probative value of admitting this evidence outweighs its prejudicial effect to you, the solicitor will be able to introduce your record to attack your credibility. Now, are there any prior?
No, Your Honor.
All right. If you decide to testify, this decision on your part must be freely, voluntarily, and intelligently made with the knowledge of the protections given to you by the Fifth Amendment to the United States Constitution and the consequences of your decision to testify. If you decide not to testify, I will instruct the jurors that they cannot give the fact that you did not testify any consideration whatsoever, and that there is to be absolutely no prejudice to you because you did not testify. It's left entirely up to you whether or not you testify. You may talk with your attorney, your friends and family, or anyone else, but the final decision will be left entirely up to you. And do you understand what I've explained to you?
I do.
Do you have any questions about what I've explained to you?
No, sir.
Have you discussed with your attorneys whether or not you should testify in this case?
Yes, sir.
All right, do you feel like you need to talk to your attorneys any more about this issue?
No, Your Honor.
All right, is there anybody you feel like you should talk to about this issue before making a decision?
No, sir.
Have you made a decision as to whether or not you wish to testify in this case?
Yes, sir.
And do you wish to testify in this case?
No, Your Honor.
All right, and is this your decision?
That she's not testifying.
Anything further the defense wants on the record regarding the defendant's right to testify?
No, sir, Your Honor. We talked to our client thoroughly about her right to testify, as have you, and this is her decision, and we stand by her.
All right, anything further the state wants on the record regarding the defendant's right to testify?
No, Your Honor.
All right, will the defense be putting up any other witnesses or any other defense in this case?
No, sir.
No, sir.
All right, so I
Defense
guess all
is
we have
resting.
now is closing arguments, charges,
Wow.
and deliberations.
Yes, Your Honor.
All right, let's take about, I've got some of the charges done. It's probably going to take me about another 30 minutes. I'll finish up charges and get you a copy. You can take a look at it. You can do one of two things. If you want to submit something, you can submit something. If you want to wait and get my proposed charges, review them and see if you have any objections or additions, then you can do that as well. Okay?
Your Honor,
Yes, sir.
quick question. There was discussion about charging the jury before and then closing, or closing and then charging.
Right.
We would prefer to be charged before.
Before.
I didn't know if the state had any preference, or if you had any preference, Your Honor.
Well, I generally charge after unless both sides agree. So
That's fine, Your Honor. Whatever the state would like, that's
We
fine.
prefer after, Your Honor.
Okay, I'll charge after.
That's fine.
So, in the closing argument, since the defense has not put up anything, the state will close in full.
Yes.
Then the defense will close in full. And
Yes.
that'll be all of the closing arguments.
Thank you, Your Honor.
All right, let's take about a 3-minute break. We'll come back. Okay, yes, sir.
Let me ask this. We're concerned about one charging, you're going to be asking here, which is hand of one is hand of law. We'd like to be able to address that before we make our argument.
All right. All right.
The accomplice liability.
Let's go over that now. Is there a hand of one? I mean, you're saying she committed the act. So what evidence is there that Mr. Dontell committed the act and she was there aiding and assisting in the commission of that?
Well, Your Honor, without being able to read the defense's mind, I'm sure they are going to say that Dontell is the one who killed Mr. Rice.
Sure.
Therefore, the presence of both the defendant and Mr. Dontell throughout the night, including going to the preserve, it's up to the jury to decide whether or not they were acting together for hand of one, hand of all, but I certainly think there's enough evidence in the record with them being together the entire night. Dontell actually driving Ms. Jackson's van to the location, helping to load Mr. Rice's body into the back of the van, again, all the way through disposing of the body. It's up to the jury to decide whether or not Mr. Dontell knew what was going to happen or not. I believe that's a question of fact to the jury.
But the question is, for this defendant to be guilty under the theory of the hand of one is the hand of all, you have to have Mr. Dontell committing the crime and her there aiding and assisting in the commission of the crime. If you have her committing the crime, it's not the hand of one, unless it would be Mr. Dontell guilty under that. A hand of one is the hand of all, is that you are there aiding and assisting someone else in the commission of the crime.
But again, Your Honor, we're trying to forecast the defense argument. It is likely, I would think, that they argue that Mr. Dontell pulled the trigger. It is therefore up to the jury to decide either way. They can believe all of his testimony, none of his testimony, or part of his testimony. So it would certainly be within the jury's purview to say, well, we believe most of what he said, but we think he pulled the trigger and not her.
But what I'm saying is, what evidence has the state presented that he did pull the trigger and she was there aiding and assisting him? That's the hand of one is the hand of all. What has the state presented in its case in chief that shows Mr. Dontell committed this crime and that she is guilty as a principal because she was there aiding and assisting him in the completion of the crime?
I think that given the fact that the jury can believe all, some, or nothing from Mr. Dontell's testimony opens that possibility that he is the one, again, as I'm sure the defense is going to argue, that he is the one who fired the gun and not Ms. Jackson.
So guys, the judge is very sharp and the prosecutor's making good arguments here. I should let her be shown. The issue at hand here is there facts in the record. And remember, defense just rested, the state rested, that's it. Everything that we've heard, the evidence, that's it. There's no more evidence coming. So from everything that's been presented, is there evidence, is there anything on the record that supports a jury charge and instruction of this accomplice liability? So with this murder charge, and remember, there's no degrees of murder in South Carolina. With this murder charge, she can be found guilty if she is the murderer, the one that used the firearm as alleged to shoot Gregory Rice. She can also be guilty of murder through accomplice liability. The hand of one is the hand of all. And to argue that theory and include that instruction, if you find like something to the effect of, if you find that she was present at the time, knew this was going to happen, even if she wasn't the one that actually pulled the trigger, she is also liable for the murder. But was there evidence in the record to support that? If they lose on this, if the state loses on this, it doesn't mean the murder charge isn't going to be instructed. It just means the jury wouldn't have the opportunity to also get there through accomplice liability. They'd only be considering whether they believe Meagan got out of that car and just started shooting at Gregory Rice. So this is really, really interesting. And it's one of those things that could be an issue if they instruct it incorrectly. Could be an issue. I think they've presented a clean case that the jury's not going to get past like full-on murder. She pulled the trigger without voting guilty. I think she's cooked. But just saying.
What evidence do you have that he is the one that fired the gun?
We don't believe that he is the one, but certainly there is that possibility within his testimony if the jury believes only part of what he said.
Your Honor.
Your Honor, I'd like an opportunity then to do more research. Your Honor,
Yeah, let's do some
considering that.
research on it, and if there's anything in the record, anything in the evidence that goes to the jury that shows Mr. Dontell is the one that committed the murder and that Ms. Jackson was there aiding, assisting in the completion or commission of that crime, then you got the hand of one as the hand of all. But as I look back, I'll look back over my notes. I don't know that I recall the state putting up anything that shows Mr. Dontell is the one who committed the crime. Now, they can argue that, but I don't know that there's anything in the record from the state that shows Mr. Dontell as the trigger person, so to speak. I'll look back over my notes, you do your research, and we'll come back and readdress it.
Thank you, Your Honor.
All right, thank you. Expect about a 30-minute break.
There we go. So you heard that. The judge is like, yeah, I don't think there's anything in the record to support this charge, this additional pathway to a guilty conviction on the murder count, which is the only remaining count. So if you guys joined late, really a lot happened. We had the state rest as soon as the jury was brought in. They weren't going to continue with any other witnesses. Motion for directed verdict was granted on the conspiracy count. Now, the reason for that is because there's no evidence on the record that Meagan and Christopher Dontell conspired ahead of time to carry out this murder. That's different than the accessory after the fact, which Christopher Dontell took a plea to. I think he actually pled to conspiring too. So maybe that's a loss there for Christopher Dontell. But however, his sentencing was withheld. So if it comes before the same judge who's aware of the facts of this case, maybe that would be impactful. Then they motioned for a directed verdict on the murder. That was denied. But they're talking about, again, as we just explained, this possible jury instruction. It seems like the defense would have preferred for jury instructions to be read before closing. And I think Mr. Big Play Bray, good to see you, said, what's the difference? Now, if jury instructions are given before closings, that could just be an additional frame of reference or an anchor, a way to anchor the jury's minds as they're listening to closings, right? Oh, we heard that we have to look for these elements, so now I'm going to listen to these arguments to be made during closing. And the tricky part about that is I think that would be beneficial to whoever makes the better argument in closing, because even though closing statements aren't evidence, they're still compelling. I feel like a lot of jurors' decisions are made on the attorney's arguments and not just the evidence. It's an extreme anchoring advantage. I don't know if they're going to do it before, though. It seems like the state wants to do it after. But now they have this issue where they have to determine if the jury's not going to be charged with accomplice liability, then we're not going to include arguments about accomplice liability in our closing statements. So we can skip ahead. It seems like they're going to be researching some case law and maybe coming back to, present the judge with case law, and the judge will decide on this instruction. Look how much we're time traveling, chat. And yeah, so Factual Lie said the state didn't ask Chris if he shot, and I don't think the defense asked either. Nope. So the testimony we have is it apparently was unexpected. Christopher Dontell didn't even see it happen. He was just asked to turn around, U-turns, and then the next thing he knew, he heard the pop, 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 pop. So, and right in line here, STS. And STS says, okay, I'm putting myself in Dontell's place. But remember, this is important. Just because you're imagining yourself in his shoes, that's still all we seem to have on the record. So, STS says, I believe he was surprised by Meagan's actions. This explains some of his missteps in disposing the body. And I agree. Yeah, in Brooklyn, it doesn't look good that Dontell took a plea. I agree. There's so many ways that could be leveraged. I mean, the state can say that's him taking accountability for what truthfully happened. Why would someone commit to 2 serious charges? Obviously, the defense could say to avoid the more serious charge or get leniency. So I think we're going to see that plea deal argued. The state has to address the plea deal, and it obviously serves the defense to point over to the plea deal. Hey, for always, forever, for life. Good to see ya. And guys, remember, we are going to do a little bit of verdict watch here. If we see stuff come in for Karen Reed, we'll check that out. Although I know a million people are going to go live and cover the verdict, so feel free to check that out as well if that comes down soon. Casey Dog, good to see you. Ronnie, good to see you. And Janice. Yeah, Janice, good to see you. Now let's see. All right, they come back right about here.
I'll give you two opportunities to raise an objection to the charges or request additional charges. One is now, and then another one is after I charge this jury. Because sometimes it does sound differently when you hear it's charged orally versus reading it on a sheet of paper. Now, before we go forward, I did include the hand of one and the hand of all. Go back over my notes and recall the testimony. The fact that under Mr. Dontell's examination, it came out that he was charged with murder and conspiracy, and that he worked out a deal in January, I think it was January when his case was called for trial, whenever that his case was called. I think that creates evidence that, yes, he may have been the one that actually pulled the trigger, and therefore the hand of one is the hand of all that she was acting with him. The fact that that came out during his testimony.
I don't know. I would argue this if I was the prosecution. Maybe they will, maybe they won't. But there isn't a plea to the murder charge. There's only a plea to the conspiracy. So the judge is saying because there was a plea to the conspiracy, and this is the tangled web that plea deals weave, because there was a plea to the conspiracy, that aspect of the plea is enough to warrant a hand of one is the hand of all, accomplice liability instruction to the jury. And then the crazy part is in this trial, he just granted a dismissal of the conspiracy charge because there isn't evidence on the record to establish at face value that Meagan conspired with one or more other parties to commit this murder. So, Brooklyn, this plea deal is coming back to, I think it's helping the state here. For whatever reason, the state wants this option, the additional pathway to guilt.
Testimony does show that there is some evidence there where a jury could believe that yes, he's the one that committed the crime as the actual perpetrator. That's why I included it in there. Anything from the state?
Nothing from the state, Your Honor.
Anything from the defense?
Yeah, respectfully, we maintain our disagreement with court on handle one and for all, there's no reason to argue that.
I understand. And your objection's on the record, and before I started reviewing notes and going over the charge of the hand of one and the hand of all, I was inclined to agree with you. But then I do recall Mr. Dontell's testimony where he was charged as the principal, and then the day of his trial, he made the deal with the state and pled to accessory after the fact. So I think there is evidence there that he committed the crime and she was acting. That's the reason I want to get on the record, the reason for my decision. All right, anything from the state before we bring the jury in?
Your Honor, if I can just have a moment. I was waiting for the final ruling to make sure I didn't need to make any adjustments to my PowerPoint, so I just need to set it up.
That'd be fine. That'd be fine.
All right, so while they do that break, you guys, or shuffle around, check this out. So the jury in the Karen retrial asked 3 questions earlier today. They just asked another question. Let's do the original 3. What is the time frame for the OUI charge? So operating under the influence of liquor. Is it 12:45 a.m. or 5 a.m.? 2, are video clips of Karen's interviews evidence? How can we consider them? 3, does convicted guilty on a subcharge convict on the overall charge? Because there's lesser includeds on the verdict form. It looks crazy. And the upper charge for the OUIs would be manslaughter. So I thought it was, jury questions can be reading tea leaves, but I thought this pointed pretty strongly to the jury has found not guilty on manslaughter, but they are weighing the lesser included of operating under the influence. So now they ask another question. After they had lunch and a little bit more time to deliberate, they asked another question. If we find guilty on 2 charges, is it hung on all 3 or just 1? So this to me is suggesting that people are divided on this OUI charge and might be hung on that, and they don't want to leave the manslaughter charge hung. This is crazy because that's very reminiscent of what happened with the first Karen Reed trial, where, they didn't poll the jury and Karen Reed is now being retried on everything. because they didn't know when we've had jury interviews and juror affidavits that stated, no, we were unanimous that she did not murder John O'Keefe. And I think it was the same thing. OUI wasn't attached last time, but it was, an operating a vehicle, or leaving the scene rather than the manslaughter. So we don't know exactly the specifics of what they were hung up on, but they were 4 or 5 different jurors signed sworn affidavits that they were unanimous, that they were not guilty on the top charges. So this is just, but yeah, I mean, I think the correct answer is that they can say that they were not guilty. They can write not guilty on these 2 charges, but I'm not sure if they can actually write in on the lesser charge. And one would wonder, if I was on a jury and I got an answer to this question, if I was the one that was like, you know what, she was drinking and operating a vehicle, I can see that, like, that one, it seems like the elements were met. But you told me, if we hang on this because the other jurors won't budge, then she could be retried on manslaughter. I'm jury nullifying all the way. Sure, I might think she was guilty of this lesser, but because it would be a hung jury and she'd still be facing manslaughter, forget that. Forget that. That's my take. For Always Forever for Life says the verdict form is purposely confusing. Yeah, if you guys haven't seen it, let me pull up the verdict form. And they made adjustments to add not guilty lines. Let me see if there's an updated version of it that we can see. A quick search, I'm not finding the updated version. So what I'm pulling on screen, let's see, is it has updates now. It's not exactly the same at this point in time. So the first page is just about the murder in the second degree, where you can very clearly see not guilty or guilty. The next page is a hot mess. You have this, the offense manslaughter while operating a motor vehicle under the influence of liquor. And now you see there's 5 items here. Item 1 and item 2, not guilty or guilty. And then you can also check, if you think the alcohol level of 0.08% was proven. But once you get past items 1 and 2 of not guilty and guilty, 3, 4, and 5 are just guilty, guilty, guilty of lesser included offenses. So what the jury's concerned with is, if we check one of these, or if we're hung on one of these, and they specifically asked about number 5 as an example in their first round of questions on their note cards. If we check this off, or if we're hung on this, then what happens here? What happens here? Because it's not like this is inset over here. And from what I heard, they made some changes to the verdict form where, Bev tried to instruct, you must first determine if they're guilty or not guilty. If they're not guilty, then you stop deliberating on that charge and move to the next one. So this form might again look different. And then obviously the third. So maybe they're stuck on this one. I don't know. Leaving the scene of an accident resulting in death. In the above titled case, obviously not guilty or guilty. A lot simpler than this manslaughter charge. So, and then Factual Lie says Bev's reply, this is not a question I can answer. Defense asked for 2 minutes to talk. Bev gave them one minute to talk. Oh my goodness. Just rush along on a significant thing. And the crazy part, guys, is I really think if this is hung, I think the Commonwealth will pursue a retrial. Like, just crazy. So with that being said, we'll keep looking for updates. Thank you, Factual Lie, for the relay. Tabiz TV says those charges should not be on the verdict slip. Verdict slip should reflect the indictment. And there's exceptions for that with what statutes allow for lesser included. I mean, we saw that a bit. That was the trap in the ASAP Rocky trial, right? Because of the way that it was charged, they couldn't include like a simple assault as a lesser. So they were kind of stuck. They wanted to charge it with something super scary, and they couldn't include more minor lesser included because it wasn't allowed by statute. These are allowed by statute. Although I don't understand the difference between a naked OUI operating under the influence versus an OUI with a 0.08% threshold blood alcohol level established. And when I was looking at sentencing, I didn't see sentencing guidelines for just a naked OUI. I only saw it, they all had that 0.08 threshold and then the number of offenses. This is your first offense, second offense, or it's while you're operating a boat rather than a motor vehicle. So I don't really understand, because to me, just a vague operating under the influence, that's very vague. It's very vague. So let's get into this. We'll keep looking at Karen Reed updates. Let's see what we get with this decision on if the accomplice charge instruction, which is now seemingly going to be included, if that changes the state's wishes on instructions before or after closing statements.
Oh, and as she go ahead and do this, I'll do however y'all want to do, since it's just one indictment and it's going to be just guilty or not guilty. Typically on that, I just send the indictment, let them write the verdict on the indictment rather than, there's no lesser included offenses or anything where I need to do a verdict form. Is that all right to say?
It's fine with the state, Your Honor.
That's fine, Your Honor.
Okay. I guess when we bring the jury in, the state is rested, I'll ask the defense if there's anything you say the defense rests.
Yes, sir, Your Honor.
Yeah, we'll rest, Your Honor.
Yes, sir, Your
I'll
Honor.
let it rest on the record in front of you.
Yes, sir, Your Honor. Thank you.
Did you notice the court like dimmed the volume down there? They like decrescendoed it.
Your Honor, I'm sorry, if the defense is going
Fading
to
us
remove
back
their motions after they rest, would it make sense to argue them now rather than having the jury come in and out?
And I never really understood that. I don't know if they can make motions after they rest when they don't present
Right.
anything, because there's nothing to
Different.
present, and I think their motions and objections are already served.
Okay, I wanted to avoid them coming in and out.
All right, anything from the defense before we bring the jury in?
I believe, Your Honor, that would do it if we're going to be done with arguments. If we just have our objection to the one involved, which is noted. Besides that, Your Honor, I think we'll be ready to proceed.
All right, let's go ahead and bring the jury in.
And by the way, for Karen Reed, I think Defense Diaries was doing like a in and out panel show with guests popping in all day. They had Cammie and potentially Criminal on already. I think they mentioned Andrea Burkhart maybe popping in or just doing a recap. I know yesterday they had a huge panel. So if you're looking for Karen Reed but don't know who's going to be popping up, I think a lot of people are pooling over to Defense Diaries. Okay, Andrea's live now. Thanks, Factual Lie.
gentlemen, welcome back. Please make sure you have your own notepads and no one else's notepads. The state has rested their case. The defense which presented anything.
Your Honor, the defense rests.
All right. Ladies and gentlemen, the defense has rested their case. So all the evidence has been presented to you, and now is the time of the trial where the attorneys will make their closing arguments to you. Now, just like their opening statements, these closing arguments are not evidence. It is simply the attorney's contention as to what they think the evidence has shown and the law to be applied in this case. If at any time an attorney references a factual issue that is different from the facts as you find them to be, or references the law that is different from the laws I will charge you at the close of their arguments, then you're to disregard that portion of their arguments, because this is not evidence and it's not a charge on the law. It is just the attorney's contention as to what they think the evidence has shown and the law to be applied. All right, state wish to close?
May it please the court.
Yes, ma'am.
This is a tale as old as time, as you were told in the opening. It involved an affair, a pregnancy, and a murder. But there was a fourth aspect of this case that is equally as important, and that's deception. The defendant was the center of the affair, certainly the pregnancy, and most definitely the murder. But the evidence has also shown that she was the center of the deception. In fact, she is a master of deception. I guess the correct term would be mistress of deception, but master of deception is a little bit more common. As you learned during the trial, the defendant and the victim had 4 children together. You actually heard from their oldest child. And think of the strength that that took Savannah to come in and testify against her mother in the murder of her father. They had 4 children, but they had been separated for about 10 months to a year before Greg Rice was murdered. They still had that connection of children, as you always do when you share children with someone else. And as you review the exhibits, because you'll get to bring them back into the jury room with you, you will see that their conversations were mainly about the children, about Greg wanting to pick up the children. When can he see them? So that was the tie that bound them together. The defendant, meanwhile, was involved in body transports. She comes into contact with Christopher Dontell during the course of her work, and she sets her sights on him for some reason.
Thank you,
She begins to
David.
show up at his favorite restaurant. She ingratiates herself to him, and they begin an affair. She infiltrates the Dontells' marriage and life. She moves to their community. She showers them with gifts. She and her children spend, if this was COVID, Erica Dontell testified that they spent almost all the time together, her family and his family. And then she began to spin her web of lies because she wanted to destroy the Dontells' marriage. But she also wanted to get rid of Greg. And so she started to frame him for revealing information about the affair. You may recall that during the trip to Florida, that was the defendant, Mr. Dontell, Savannah, and one of Savannah's friends, the defendant showed Dontell one text message. All I can say is wait for the storm. And based on this text message, she told Dontell that she was terrified of the victim. Didn't want to be near him. He was hell-bent on hurting her. You have to come with me. I'm going to confront him, but you need to be there because he is going to hurt me. Remember, all I can say is wait for the storm. But, and I know it took a little bit for Lieutenant Wells to read through that whole conversation, but especially here, the context of that one text is extremely important. Because you should recall, and again, you will have the exhibit in your room with you, that the conversation was about the children. Greg did not know that the defendant and Dontell were in Florida. He thought they were in Ohio. He was caring for the other 3 children, and the defendant had stayed away longer than she had told him she would.
Yeah, that's STS.
And his
dropping
job
5
was
more
suffering as
subs.
a result. He couldn't work because he had to care for the children. And so that's what, he continually caught her in lies. You told me you were going to be home yesterday. You told me you had a court date. I'm tired of all these lies. So the storm was to expose the lies. I don't trust a word you say. Everything is always riddled with half-truths and lies, so I'm going to start letting people know the truth. Not, I'm going to kill you, I'm going to hurt you. It's, you lie to me, and your lying to me affects my life. And people need to know that they can't trust what you are going to say. Again, if you look at the entire conversation, you will see that Greg is saying, thanks, just text me when they're ready, please. Hope your day is going well. Boy, that sounds like someone who is out to hurt someone, right? When can I pick up the kids? I hope your day is going well. Greg was not threatening the defendant. Greg's only concern was seeing and caring for his children. The defendant, on the other hand, so go ahead and run your fucking mouth again. Thanks for being an ass about it. Who in that text conversation was more aggressive? It was the defendant, not Greg Rice. Greg Rice had no intention of hurting Meagan Jackson. So the defendant comes up with this scheme that she is going to expose her affair with Christopher Dontell, but she's going to pin it on Greg Rice. So she begins with these text-for-free messages. One of them included the list of the 4 people who had gone to Florida. That couldn't have come from Greg because he had no idea where she was. He thought she was in Ohio. He certainly didn't know that she was with Christopher Dontell because otherwise that would have come out in the text. So this text came from Meagan Jackson. How else do we know that the defendant is the one who sent these text-for-free messages? If you look at, there was one IMGBB link that you can make out. This is what pulls up. At the top of that is Christopher Dontell's number, meaning that this is a photo, not even just a capture. This is a photo, someone taking a photo of the defendant's phone and sending that, uploading it to IMGBB and sending it to Erica. Lieutenant Wells showed you that text conversation in the defendant's phone. How would Greg get the defendant's phone in order to take a photo of this text conversation and send it? How would he even know about this text message? And if you read the content of this text message, believe me, it was specifically chosen to hurt Erica the most.
That's a
Then,
good point.
when that didn't work, the defendant started this, she sort of upped the ante a little bit. She started talking about a package is going to be coming in the mail. And already she's, again, blaming Greg. Blaming Greg. And let me actually backtrack for 1 minute with the text-for-free messages. Don't forget that when Erica said to her husband, call her now, and they called the defendant, who did the defendant say was sending those messages? It's got to be Greg. There's no evidence in the record that Greg cared a whit about who the defendant was sleeping with. All he cared about was his kids. But when the text-for-free text did not work, she begins this campaign about a package coming in the mail. And again, she's blaming Greg. So this is really a win-win situation for her. She's telling Dontell to intercept the package. Okay, well, if he doesn't intercept the package, then number one, it hurts Erica, perhaps drives a bigger wedge in their marriage. But Dontell is going to think that Greg is trying to destroy their marriage. But if Dontell does intercept it, again, there's still that notion in the background, look what Greg is doing. Look what Greg is trying to do to your marriage. So she had started this little campaign about the package on September 28th. And then on September 30th, we see, and I tried to put the exhibit numbers here so you'd be able to reference them if you wanted to. We see on her web searches that she searched for the location of both the UPS store and the FedEx store, or that she was actually at those two locations, further indicating that she is the one who sent the package. Even more telling is the fact that she deleted her search for the location of where the FedEx store is. How many people here have ever gone to the trouble of deleting a search for a location as bland as FedEx. Further evidence that she was trying to frame Greg for sending this package. So Dontell was able to intercept the package, and you may recall that he said, I opened it up, I didn't look a lot at it, I just brought it over to the defendant, but it was photo collages and pictures of text messages. So then we move on to the notepad, the links in the defendant's notepad. Now remember that she started these text messages about the package coming on the 28th. Well, on the 27th, she starts uploading all of these images into IMDb, setting the stage. And again, notably, October 2nd, she sends that to the trash. But Lieutenant Wells was able to access each one of those IMDb links, which she was also able to show you were cached in the defendant's phone. Now, these are just some of them. I think it was exhibits 100A through S, right? But if you look at these text conversations with Dontell's number at the top, photo collages, exactly what Dontell saw in the package. And then also, while this is going on, while the defendant is feeding Dontell this pack of lies about Greg is trying to expose the affair, I'm so scared of Greg, we have evidence of further malice towards the victim, where there was a text message about popping a tire. I'm all for popping a tire now. So the package still doesn't work. Dontell is still married. He's still married to this day. Whether you agree with her decision or not, Erica Dontell did not leave her husband when word of the affair came out. Did not leave her husband when word of the pregnancy came out. Did not leave her husband when he was arrested for murdering his lover's baby daddy. Still has not left him. So the defendant's campaign to destroy that marriage didn't work. But she kept trying. So then we get to the H-Gate email. And if you recall, this H-Gate email, which was sent on October 1st, but there was evidence that the defendant's phone had accessed that account on September 27th with a password that was stored in the keychain of her phone. So she's accessing that email account a full 4 days before this email is sent. And the email is sent, so let's widen the web a little bit here. It's not working that I just send things to Erica Dontell. Now the defendant's including Erica Dontell's sister and father. Maybe this will work. Maybe this will break up the marriage. Again, trying to blame it on Greg, but how is Greg going to get these images? These are all clearly from the defendant's phone. And Lieutenant Wells told you that he found them in the defendant's phone. So while she is saying at every chance she can get, Greg is doing this, Greg is trying to expose the affair, this is all Greg's fault, it is clearly her fault. And when this still doesn't get the desired result, the next step of the plan goes forward. So this email was sent on October 1st. Now we go to October 2nd. And they go to the preserve where they have been on the 29th, the 30th, and now the day of the murder. And they engage in target practice. So on October 2nd, they were together all night. Christopher Dontell told you that, but the evidence tells you that also. As you think through Christopher Dontell's testimony, think of how it's corroborated by phone records, surveillance videos, LPR photos, starting when they left their community, the community that the defendant moved into, knowing that the Dontells already lived there. So they're leaving their community within moments of each other. And the phone activity shows the same thing. They go to the preserve, again for target practice. We see both cars leaving. We saw them coming in as well, but there they are leaving. There are the phone records showing that both phones are hitting off the tower that serves the preserve. Then they go to Abuelo's, seated at the bar together. Again, the phone records show that they were together all night. All the way through to 11:06, 11:07 p.m., the last connection that Greg's phone makes to any tower. We ran the surveillance video for you from Just Ask How, or the Lowe's food parking lot. You see the defendant's van and Dontell's Ford Explorer. You see them, you never see Greg. Why? Because he was being stored in the Myrtle Beach Funeral Home cooler. We know that the defendant was the last person to talk to Gregory Rice. Twice. First she calls at 9:45, and then again at 9:58. And at that point, Greg Rice starts walking towards the Clay Pond Road entrance to the Arrowhead community. They leave Arrowhead at the same time. Again, supported by the phone records. And we know what happened during that 6 or 7 minutes in the Arrowhead community. Christopher Dontell testified he was driving the defendant's van. As they're pulling down Arrowhead Boulevard, they see the victim walking down the road. Dontell begins to pull over, and the defendant says, "No, turn around, make a U-turn and pull up in front. Don't be awkward." And then as soon as he pulls up, the defendant jumps out of the car and fires multiple shots, killing Greg Rice. And what's interesting is every single shot is on the left side of the body. So picture this, that the van is in front of me. I'm Greg Rice, I'm walking up, door opens, I see the defendant hop out with a gun in her hand, and I start turning to run for my life. Shot, 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 shot. He saw it coming. Now, the defense made quite a bit of, well, everyone, like Captain Wilson, did you park in the lot? Did you go to the sidewalk? Did you walk up to the apartment? Did anyone say shots fired? Did you see any crime scene? Focusing first on whether or not there were any calls about shots being fired, I suggest that anyone who has lived in Horry County for any length of time has heard gunshots. And quite frankly, if you called the police every time you heard gunshots, you wouldn't have time for much else. But what you should also consider is where the shots happened. Next to this 8-acre tract. And there was testimony, I believe it was by Sergeant Jones, that a shot from a .22 caliber, which is what the murder weapon was, is much softer than, say, a 9mm or a .357 Magnum. But the fact that no one called in shots fired is really of no moment. Again, we go back to the last data connection that we have with Greg Rice's phone. And as you were watching that sort of animated slide, Sergeant Marcus loves these animated slides, puts them in every presentation. But if you looked at that animated slide detailing the last sort of life of Greg Rice's phone, you will notice that Greg's phone is tracking with the defendant. At one point in that animation, it was geolocation data of the defendant with Greg Rice's phone. Christopher Dontell also told you that after they had stored the body in the funeral home, at some point in the evening, the defendant wanted to go back and get some of Greg's belongings so that she could plant them at the apartment and kind of give life to this missing person story. Well, how do we know that that is accurate? Because he told you about a trade embalmer. I learned a lot about the business of death in this case. I never knew that there was a trade embalmer, someone that would show up at a funeral home at midnight to embalm a body. But sure enough, they did. And again, geolocation data shows that the embalmer's wife, Joanne Cusack, was at the Myrtle Beach Funeral Home at the same time as Meagan Jackson, her geolocation data. And that's at 12:38 at night. So, based on everything that we had seen so far, all the evidence that has been entered, the defendant was charged with murder. Now, typically, the prosecution and the defense fight over just about everything. But I cannot imagine a reasonable argument that Greg Rice was not murdered. Shot a minimum of 5 times and dumped in a river to be found 5 weeks later. So then, what it is up to you to decide is the defendant guilty of the murder? Certainly, by Mr. Dontell's testimony, she is. If you have any hesitation about that, then South Carolina has hand of one, hand of all. If they were acting together, and you heard that he had originally been charged with murder and criminal conspiracy and accessory after the fact, entered a plea with no agreements with the state to criminal conspiracy and accessory after the fact. So if you think, well, maybe Dontell did it and not the defendant, you go back to this hand of one, hand of all, which says that it doesn't matter. 2 people can be guilty of killing another when only one of them has a gun and only one of them fires a shot. But I would suggest to you that there should be no question in your mind who fired the multiple shots that killed Greg Rice. Because all you need to do is look at who benefited from his murder. Christopher Dontell and Erica Dontell never met Greg Rice. Never. The news of the affair and the pregnancy was already out. So what benefit would it be to kill Greg Rice? You can't stuff that secret back in the bag. And as I said before, the news of the affair and the pregnancy did not end Dontell's marriage. The defendant is the only one who benefited from Greg's murder, and I think that's evident in the seeds that she planted along the way. In a moment, after defense closing and the judge's charge, you will be asked to render a verdict. Verdict in Latin means to speak the truth, something I would suggest the defendant has an extremely difficult time doing. But it is your job to end the defendant's continued deception and speak the truth and convict her of murder. Thank you.
All right, chat, what do we think? What do we think of the prosecution's closing argument? I thought they did... Oh, I'm off the screen. Where am I? Okay, I'm here. I thought they did a great job. They got a whole bunch of stuff in evidence, and they didn't really harp on it during testimony with witnesses on the stand. They just got it into evidence and then relied on it to make their arguments in a linear fashion in closing. And that's kind of what you'd expect of trials, but when we're used to watching things like YSL and Karen Reed, I think Hank was just... We don't really know for sure what happened, even though we're supposed to tell you we know what happened beyond a reasonable doubt. You know, it's just nice to see a concise closing argument. And here's what we have. Here's what we're asserting happened. And it's your job, jury, to determine the truth based on the evidence presented to you. Nothing more, nothing less. With that, defense will be next. I wonder if it's going to be the same attorney that did openings, because we haven't really seen much of him after like the first day. So For Always Forever for Life says pretty good. Plans and Pen says, if Greg didn't care who she was sleeping with, why kill him? Maybe I'm overthinking it. That's a question I have. I'm still confused on the pregnancy. Like, was it truthful? Whose kid was it? If she was pregnant? Like, there's some gaps there. There are some gaps. STS as a book editor would be satisfied with the outline. I like that. I like that. Gap Girl, good to see you, says good evening. Hey, I'm only 2 o'clock over here. We still got afternoon vibes going on. Also, huge shout out while we were doing the closings from the state. Taybiz TV came in and sponsored 5 gifted memberships, so make sure you're saying thank you to Taybiz if you got one from him. And then STS, another 5. So we had 10 gifted subs. So if you're suddenly green, thank Taybiz, thank STS. Super generous of them to do that, and they don't have to do it. Yeah, STS is thinking no way she was preggers. The timing of that just seems like it was to her own benefit to say she was and just maybe send this fake sonogram picture and hope it doesn't get questioned. Factual lie says, was Greg insured? Now, I mean, I don't specifically know the details of that. I think that that's something that might... There's a few cases against Meagan open. But there was, I think it was from the Independent. The Independent did an article on this case in the early days. And they mentioned that, you know, I think Meagan Jackson's mom died kind of unexpectedly. And they didn't really go into much detail, but they mentioned it in the article. And so, like, this insurance idea is, you know, it's always a reason, right? Always a reason. People wild out when it comes to the opportunity to come up on a bunch of money. So, Plans and Pen says, I think she just wanted to unalive someone and had her sights set on Greg, like making her seem unhinged. And that's the thing. If she's saying something in these texts and then Christopher Dontell responds like, haha, something to the effect of kind of being with that in regards to the brake line and popping the tires. Could he be serious when he says that? Sure. Could he also just be like, she's saying that in jest, so I'm going to ha-ha with it, and I'm not conceptualizing or even thinking that she might be dead serious about what she's saying. I'm just having this conversation back and forth. That's another possibility. So Gap Girl, will I be streaming the Sandra Birchmore trial? Maybe, but that's another case where I feel like there's so many people that have followed that in depth, in detail, where, you know, I probably would lean towards being in the bleachers on that one, right? And learning from those who have done the deep dive and focused in on it. And that's, guys, so Sandra Birchmore, I think that's like coming up. At least like pre-trial stuff, pre-trial happenings. There's starting to be more momentum there. And yeah, for Always Forever for Life, her facials show that she doesn't really care one way or the other. That's how I read the expressions as well. I'm not sure how well the jury can see her face, but, you know, if they can see it, they can judge it. So, let's get to the defense closing arguments, you guys. Let's see what they do, and let's see who's doing it.
Your Honor.
She's just going to take this down, Your Honor. So.
25. Good morning. What you're going to hear in the jury charge, in terms of reasonable doubt, you're going to hear reason to hesitate. What you're looking for in this case is a reason to hesitate. And in this case, there are many reasons to hesitate. How about the first one? Every word that was just uttered to you would have been used in a trial to try to convict Chris Dontell of murder. Every single fact you have heard just 7 months ago, and it should scare you, would be used to...
Oh, did they go over law and crime? We just got an OnlyFans appearance.
So let's look at what you're going to hear. You're going to hear the court's going to tell you about not holding it against the defendant for not testifying, and take that to heart. It's part of your constitutional right. And think about this for a second. When it comes to who didn't testify, you can't consider Meagan Jackson didn't testify, but you should consider the fact that they never put up the chief investigating officer. He never took a stand. You want to know why? He didn't want to co-sign this. He's ashamed of what this case looks like. Because he knows what I know, which is for you to convict Meagan Jackson, you have to believe Chris Dontell. And that's something nobody should have to do. Let's look at what they actually presented to you. Because once you remove Chris Dontell, what you start to see is there's not a whole lot of evidence of a crime, of an actual crime. They've shown to you Meagan Jackson wanted Chris Dontell to have the courage to go tell his wife about their affair. She wanted him to go tell him. That's not a crime. Now, did she do that in ways that maybe we wouldn't agree with? Sure. But her wanting that marriage, that affair to be outed, that is not a crime. And the fact that they're trying to get you over there and make that the case should tell you they have a lot of weakness in their actual case. An actual case requires them to prove things that happened at the time of the crime, which they can't do. Because for 4 years, they've been telling themselves, and anyone who will listen, that this happened at the Myrtle Beach Funeral Home. It wasn't until 7 months ago that they started telling you it's Flint Lake Apartments. How can you believe and not hesitate when they have shifted the crime scene 4 years later? Does that make any sense? So what did they present? Well, they presented some evidence about where phones were. You got some phone information. Okay. The problem with phone information is this. It doesn't put you in the actual what's going on moment. It doesn't tell you if Meagan Jackson drove Greg Rice alive back to the Myrtle Beach Funeral Home and dropped him off so that he could talk to Chris Dontell. It doesn't tell you she went inside. It doesn't tell you what's actually happening in the moment. And they knew that coming into this case. Do you think it's a coincidence that he wrote a statement out, Chris Dontell did, and hand-delivered it to Ken Marcus, and an hour later, the state has it changed? I mean, he hand-wrote a statement and told the state he did not see it happen. He was not present. He was not there. That is what he told the state. And an hour later, that's changed. Now all of a sudden, he's an eyewitness to it? If that doesn't give you a reason to hesitate, I don't know what else could. I cannot think of something more important than the fact that that man would change his statement within 1 hour to assist the state to try to convict Meagan Jackson. See what that does? It tells you exactly what he's about. He's about Chris Dontell. He's about himself. That's the reason he wouldn't tell Erica. That's the reason he's pushing Meagan. And that's the reason he killed Greg Rice, because he is about himself. What else did they present? Well, look at some of the other investigators. I have never seen the investigators that took this stand. They looked sad up here. They were ashamed of this. And you should be. I mean, you spent 4 years telling everybody this happened at Myrtle Beach Funeral Home. And the one thing that changes your mind on that is the testimony of Chris Dontell. That's the only piece of evidence that changed what they believe happened that night. Can you count on Chris Dontell? They shuffled up 2 dentists. I don't know why. They shuffled up 2 ballistics people. I don't know why. I'll tell you, I do know why. Because if you don't have real evidence of what happened in terms of crime, what you do is you expand this trial. You go put a bunch of evidence in, so when you go back there, you go, man, look at all this. But ask yourself as you're looking at it, does any of it actually prove what happened? You can piece it all together, but when you get right down to it, you're always going to have to come back to trusting Chris Dontell. And that's the one thing the state didn't want you to have to do, but they could never get around that. Let's talk about some of the things they clearly missed. They want you to believe that she returned a wallet and keys the following day. You might have heard of that. The wallet and keys are sitting right there in evidence. Guess what you don't have to go with those? A DNA sample. You talk about easy. You talk about simple. Send the keys off. Have the DNA checked. Comes back Meagan Jackson, you might have a little something. They didn't do that. make sure you look at that blanket or that sheet. They want to tell you that sheet is evidence that Meagan Jackson had that in her van. Remember what they told you about that? They told you it looked like it came from the Myrtle Beach funeral home. Guess what that evidence was going to look like 4 years ago? 7 months ago. 7 months ago, that evidence was going to be that sheet. That sheet is evidence that Chris Dontell was sitting there in the Myrtle Beach funeral home when Meagan Jackson brought Greg Rice there and he killed him. That isn't a Grindstaff. She worked for Grindstaff Transport. That was a Myrtle Beach funeral home sheet's what they told you. It's sitting right there with Chris Dontell. The reason they didn't like that is because they could never prove to you, and still haven't to this day, what was going on in her mind. But I think we kind of know. She showed up on October 2nd with what? When they went to the shooting range, what did she have in her car? Blow up Betty. She's still trying to woo Chris Dontell. She got blow up Betty. She's not worried about shooting targets. She's looking to have more sex, and that's what their relationship was about. You could pick any night from the time they started dating, and they are together, they are swapping cars, they're having sex in their car. That's what their relationship was about. And she was true to that on the night of October 2nd. That's what she showed up to do. Do I think she wanted Greg Rice to help her out this affair? I absolutely think she did. Was Greg Rice an imposing guy? Yes, he was. If Greg Rice had a chance to talk to Chris Dontell and tell him, hey man, get your stuff straight, I think he'd have done it. Go tell your wife, I think he'd have done it. And that's what Meagan Jackson wanted him to do. She wanted Greg Rice to help her get Chris Dontell to man up.
Objection, Your Honor. This is all arguing facts, not evidence.
Listen, I'll let her go.
Go ahead.
Thank you, Your Honor. That's exactly what was going on. That's what they've proven to you, is that she wanted this affair to be out. That's what they have proven to you. And did she go about it the right way? Maybe not, but she wanted it to be out. What is also true, when we start talking about motive, her and Greg Rice's relationship, yeah, it's typical ex stuff. They talk a little vulgar to each other, you know, they fight over kids. It's typical marital, ex-marital. There's some nastiness in there. But Greg Rice, having him in her life was a benefit to her. They made a big deal telling you she's not the best mother. Well, guess what a mother who's struggling needs? Help. Getting rid of Greg Rice gets rid of her help. There is no motive there. But think about Chris Dontell on the other hand. Chris Dontell is getting word that he's about to lose Erica, could be losing Meagan, and that Greg Rice is complicating his life and is going to out his affair. There's a text. If he sees Erica, he's going to tell her. So the only person that actually has a motive, a true motive, to get rid of Greg Rice is Chris Dontell. And can you trust him? Can you trust him? Well, let's consider some reasons why maybe not. Got a little list here. Reasons that you should not trust Chris Dontell. He doesn't even recall his plea. He doesn't even recall his plea. He sat up here 7 months ago, took the plea, where he slithered his way out of the murder charge, and he doesn't remember. His handwritten statement to Marcus. His handwritten statement to Marcus that he changed within 1 hour. That's the second reason. He sat here and told you he was scared of Meagan Jackson and that he's sleeping with her. After this occurs, and he tells you, she did it and I had to watch it, I had to watch it all. He's sleeping with her. Do you think that that's really, do you believe that? No, you can't believe that. How about this, man? He slipped this right by you. The only person who has Greg Rice's blood on him is Chris Dontell. That's it, guys. The case should be over. The only person with blood on their shoe is Chris Dontell. How about this? He tried to tell you that Meagan Jackson went home after this, went from Lowe's, they went home and she showered. She got all changed up. Had to get the blood off of her. Well, guess what? If you saw the surveillance video footage, when they go back to Lowe's, she's wearing the same exact thing she was wearing when she left Lowe's the first time. She hadn't changed her clothes. She was wearing the same black scrubs. Can't trust Chris Dontell. Who disposed of the body? Who disposed of the body? Chris Dontell. Did he strike you as the kind of guy who's going to do you a favor? Is that the guy you want to go to for a favor? He is the most selfish person I've ever seen. He sat up here and told you he disposed of the body as some kind of favor. You ain't buying that. You can't. You know what? He did a lot. I called him Chris Dontell, full of lies and cries. I'll tell you when he wasn't crying. He wasn't crying when he was shopping in Lowe's. Just grabbing cinder blocks and tarps, stick them in his grocery cart, and let's grab the Pepsi. He was mortified about what had happened. He looked pretty casual there to me. I don't know about you.
Pepsi.
How about that very sweet wife of his who sat up here and remains committed to him after he sent these heartfelt texts about how much he loved her and was going to stay with her after he killed Chris Dontell. He's still sleeping with Meagan Jackson. Can't trust him. How about the fact he's seen sneaking around looking for a key in a Myrtle Beach funeral home? Can't trust him. How about the fact he lied to Meagan Jackson about where he found that key? Can't trust him. How about the fact that blow up Betty is not very good target practice? Not much of a marksman myself, but I'm pretty sure if you shoot an inflated object, it just explodes the one time you shoot it. That would be the worst target practice I've ever heard of. You would want something that would withstand some gunshots.
Yeah, blow up Betty.
And if at all you find yourself in some crazy way wanting to trust this man, I don't think you would. If I told you, he's up here testifying, trying to get his plea reduced. That's why he's here. He's here for who? He's here for himself. That's what he's here. I'll tell you something that really makes me not trust the state, frankly. Not just them having people's phones, but what makes me not trust the state. How about how they're doing you with Chris Dontell? When it suits them, he's their buddy. Hand of one is the hand of all. Meagan Jackson, Chris Dontell's hands, they'll tell you we're in the cookie jar together. Well, then he takes a plea. His plea makes it impossible for him to be charged with murder. The state took his hand out of the jar. Here's what's wicked, man. You're so wicked. And they bring him back up here and let him testify in a way where they're going to ask you to consider the hand of one and the hand of all. So what are they going to do? They're going to stick it back in the jar. When it suits them, they're going to stick it back in the jar. And as soon as we leave here, they take it right back out. That's crooked. See what else they're going to do? They're going to ask you to believe a man they don't believe. They're asking you to trust Chris Dontell, and they don't trust you. You know why this conspiracy charge is gone? The court decided that not enough evidence to support the conspiracy charge to no longer have it.
Objection, Your Honor.
This day,
Move to strike.
I strike now. That's a matter of law.
When it comes down to the hand of one is the hand of all, that is there. And I knew it in the opening statement, from the ringing bell, I knew it. We were in for a wild ride, because when you're trying to count on that to prove somebody guilty of murder, you know you have a weak case. You know you do, man. If you can't put Meagan Jackson on the scene, of course they don't have a scene here, you know your case is weak. I'll tell you what really worries me. It's not that they don't trust Chris Dontell. I mean, I know they don't trust Chris Dontell. You don't trust Chris Dontell. But what I find offensive about their position is they don't trust you. They don't trust you. Because if they trusted you, they would tell you that the case we put up here, the case we put up as the state, banks on Chris Dontell telling you she just jumped out and started shooting. I had no idea what was going to happen. That's what he told you. That is their case. That's evidence they put into the record. But now they want you to just bypass some of that. Weird stuff. So what happened? Mr. Britton, give us some theories. Well, here's the evidence in the record. Pretty simple. You can consider reverse truth. Very common. Co-defendant will strike up here, testify against their defendant, and tell you exactly what they did, and put it on the other person. Meagan Jackson, sitting in the car with Chris Dontell, they pull up, Chris Dontell gets out and starts shooting. And she had no idea he was going to do it. And that is, you can believe that all day long. That is as likely, and when it comes to motive, much more likely than the fact that Meagan Jackson would get rid of her father, or the father of her children. But that's really not what this case, in my opinion, look, when you look at Flint Lake Apartments as a crime scene, it kind of falls apart. I don't know. I mean, they had a witness who tells you gunshots are fired out there all the time. I don't know. Maybe you believe that. Maybe you don't. I find that pretty hard to believe. I find it hard to believe that when they're out there 9 times, nobody says, okay, listen, I'm going to tell you, we got gunshots out here all the time. I heard some, but I didn't say anything to you the first 4 times you were here because I didn't think it was all that important. Because we just, we don't ever report it. I find that extremely hard to believe. I find it hard to believe that they claim she's out there picking up evidence the next day and nobody sees that either, in broad daylight, with her kids running around. That don't make any sense to me. That don't make any sense to me. And it didn't to them either. So you should not feel bad about that. If that does not make sense to you, you should feel good with that. Because it doesn't make any sense. And that's why the state didn't believe it. And that's why the chief investigating officer didn't testify. It's because their original position on this is probably what happened. And then you can read into the evidence. She goes and she picks him up. And she gets him to the Myrtle Beach Funeral Home alive. And their problem is they can't tell you what happened after that. They can't blame her. And since the snake has already slithered out of the room, they can't blame him. But I can promise you, as soon as once you make that decision, Flint Lake Apartments is an unlikely spot. You have your reasons to hesitate. And the rest of this case falls at the Myrtle Beach Funeral Home, where they themselves believe it falls. Dave, the court's indulged for a second, Your Honor.
All right.
Checking in. Anything else?
Just in closing, I would just say, when you get back there, what you really follow the court's instructions, but just ask yourself at the end of the day, do you trust Chris Dontell? Because the only way you can convict her is if you trust that man. And I don't think you can. Thank you.
Right, there we go. Guys, we get to time travel. We get to time travel. We're going to hear instructions, and then we're going to time travel.
Ladies and gentlemen, all of the evidence in this case has been presented to you. The attorneys have made their closing arguments, and now is the time of the trial when I charge you with the law to be applied in this case. The indictment in this case charges the defendant with murder. The court has already dealt with the indictment charging the defendant with conspiracy to commit murder, so you need not consider that charge in your deliberations. I remind you that the fact that the defendant was arrested, charged, and indicted in this case is not evidence in this case. It cannot be considered by you as evidence of guilt in this case. Nor does the defendant's arrest, charge, or indictment create any presumption or inference of guilt. This document is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court. The defendant pleads not guilty to this indictment. That plea puts the burden on the state to prove the defendant guilty. A person charged with committing a criminal offense in South Carolina is never required to prove her innocence. I charge you that an important rule of the law is that the defendant in a criminal trial, no matter what the seriousness of the charge may be, will always be presumed to be innocent of the crime for which the indictment was issued, unless guilt has been proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not a mere legal theory. It is not just a legal phrase. It is a substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. Now, what is a reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. We know very few things in this world with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. If based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. If, on the other hand, you think a real possibility exists that the defendant is not guilty, you must give the defendant the benefit of that doubt and find her not guilty. I remind you that during this trial, you and I have certain duties to perform. As the trial judge, my responsibility is to preside over the trial of this case. I also have the duty to rule on the admissibility of the evidence offered during this trial. You are to consider only the competent evidence before you. If any testimony was ordered stricken from the record in this case during this trial, you must disregard that testimony. You are to consider only the testimony which has been presented from the witness stand, any exhibits which have been made a part of the record in this case, and any stipulations of counsel. I have the additional duty to charge you the law applicable to this case. As the presiding judge, I am the sole judge of the law for this case. Your duty as jurors is to accept and apply the law as I now stated to you. If you have any ideas to what the law is or what the law ought to be, and your idea is different from what I now tell you the law is, you must disregard your idea of what the law is or ought to be because you are sworn to accept the law and apply the law exactly as I stated to you. In every case tried in this court before a jury, the jury is the sole and exclusive judge of the facts in the case. A trial judge cannot intimate, state, comment on, or make any statement to a trial jury about the facts in a case. Since you, the jury, are the sole judge of the facts in this case, you're not to infer from what I've said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you that I have any opinion about the facts in this case. The law does not allow me to have an opinion about the facts in this case. This is a matter solely for you, the jury, to determine. As jurors, your duty is to determine the effect, value, weight, and truth of the evidence presented during this trial. Two types of evidence are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence is evidence that directly proves the existence of a fact and does not require deduction. For example, direct evidence is the testimony of a person who claims to have actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. Nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. You should weigh all of the evidence in this case. After weighing all the evidence, if you are convinced
Thank
of the
you, Peter
defendant's guilt
Ortiz.
beyond a reasonable
Some boom
doubt,
booms in the
you must
chat.
find the defendant guilty. On the other hand, after weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This burden rests with the state regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. Necessarily, you must determine the credibility of witnesses who have testified in this case. Credibility simply means believability. Your duty as jurors is to analyze and to evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in this case, you may believe one witness over several witnesses, or several witnesses over one witness. You may believe a part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety, or reject the testimony of a witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in this case. You may also consider the appearance and manner of the witness while on the witness stand. Evidence has been presented that a witness has made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use evidence of the earlier contradictory statements to determine the truth of those statements. You must decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all of the testimony of that witness or give all or a part of the testimony the weight you think it deserves. Rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witnesses. A witness who by education and experience has become expert in some art, science, profession, or calling may state an opinion as to the relevant and material matter in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct you and emphasize that the fact the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. The defendant's decision not to testify must not be considered by you in any manner whatsoever. A defendant has the constitutional right to remain silent, and the assertion of this right must not be considered by you in your deliberations. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant in this case did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove her innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances surrounding the situation. Criminal intent cannot be proven to a mathematical certainty. Medical science cannot dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances shown to have existed. This is how you make a determination of whether or not the element requiring intent is present. Criminal intent does not have to be established by direct and positive evidence. Intent may be established by inference in the same way as any other fact. by taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state, a conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances shown to have existed. Criminal intent can arise from an action or a failure to act. They may arise from negligence, recklessness, or an indifference to duty, or the consequences that is considered by the law to be the equivalent of criminal intent. Now, the defendant is charged with murder. To convict the defendant of murder, the state must prove beyond a reasonable doubt that the defendant killed another person with malice or forethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice or forethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time of the act is committed. Therefore, a combination of the previous evil intent and the act is required. Malice or forethought may be expressed or inferred. These terms, express and infer, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist, either by direct evidence or by inference from the facts and circumstances which are proven. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person, or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proved beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you, along with the other evidence in the case. You may give it the weight you decide it should receive. If a crime is committed by two or more people who are acting together in committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act, or is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or scheme is necessary for a finding of guilt as a principal. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principal on the theory of aiding and abetting. Intent is also a necessary element. For there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances for which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. Now, ladies and gentlemen, you may find one of two possible verdicts in this case. No significance is to be given to the order in which I state these verdicts to you. I simply have to state one first and one second. The possible verdicts in this case are either guilty or not guilty. Ladies and gentlemen, your verdict must be a unanimous one. Mr. Roberts, as foreperson, when the jury agrees on the verdict, you will write the verdict here under the verdict portion of the indictment. Then you'll sign your name as foreperson and date the indictment, and then knock on the door and tell the bailiff you have reached a verdict, and we'll bring you back into the courtroom at that time. Now, you have been allowed to take notes during the trial of this case if you wanted to. And I will now allow you to take your notes with you into the jury room while you deliberate on your verdict. However, note-taking is not required. Please remember that some people are better note-takers than others. Juror notes should not be given any greater weight than the recollection of other jurors. The recollections of individual jurors should be considered as reliable as notes taken by any other jurors. Now, I'm going to excuse you to the jury room in just a minute, but I'm going to tell you, don't begin your deliberations. I need to check with the attorneys to see if they have any additional charges or corrections to the charges I've given you. If they do, and I deem it appropriate, I'll bring you back into the courtroom and make whatever corrections or additional charges are needed. If there are none, the exhibits will be brought back to the jury room, and the bailiff will instruct you to begin your deliberations. But do not begin your deliberations until you're instructed to do so by the bailiff. Also, we have ordered lunch for you. It hasn't gotten here yet, but it should come shortly. When lunch gets here, you can do
Lunch
one of two
instruction.
things. You can stop your deliberations, eat your lunch, and then resume deliberations after you eat lunch. Or if you prefer, you can deliberate while you eat lunch. The only requirement is that everybody must do the same thing. You can't have some jurors stop deliberations while other jurors continue to deliberate. But whatever you choose to do, whether you deliberate while you eat, or if you want to take a break, you can do that as well. All right, I'm going to excuse you back to the jury room, but please do not begin your deliberations until you're told to do so by the bailiff. Thank you very much.
Alrighty, so guys, we're gonna listen and see if they have any last issues before they send the verdict form back. And then we'll time travel. And we'll also look at the Michael Colucci dismissal. That's also South Carolina. And it was without prejudice, so they can re-indict and bring that back. But we'll look at the details. Whisper, whisper. All right, chat, you've heard everything. Remember, the only thing on the table is the murder count. What do you think?
None from the state, Your Honor.
All right, anybody that defends?
Just a reiteration of our objection to the hand of one and the hand of all, Your Honor.
All right, I'm going to go ahead and leave that in place and state my priority.
Thank you, Your Honor.
Thank you. Anything else from the defense?
Yes, sir.
Can we,
I'm sorry.
go somewhere where we're 5 minutes away?
Right. If you want to leave, make sure clerk of court has your, or my law clerk or the clerk of court has your
Brooklyn.
number. Okay.
Yes, sir, Your Honor. Sure.
All right. Let's make sure we have all of the exhibits
Yes, Your Honor.
right here. Also, if you would go ahead and bring the alternates, and that would be Mr.
They might be doing...
Your Honor, with the court's permission, I'm going to take this to my table. and
Preparing
go
for
through and pull out the
sentencing?
ones that were not admitted.
Yeah, so I think,
Yes, sir.
I think they were muting names that they were reading to make sure they called people to the gallery,
Thank you.
which means the judge expects what? Quick turnaround. All right, I don't think he's talking. We'll make sure we catch anything before we jump ahead. And they might just be going to deliver. Oh, they got something here.
Ladies and gentlemen, this is the part of the trial I hate, because the law says that since we still have our 12 jurors, it does not allow the alternates to participate in the deliberation. I hate that because we make you sit through the whole trial just like regular jurors, but then we don't let you make a decision. I want to thank you for your service. That'll conclude your service for this term of court or for this trial. You're at liberty to do whatever you want to do. If you want to stay and see the outcome, you can do that. We've got lunch coming. If you want to stay and eat lunch,
Would you stay?
do that. If you want to leave now, you can do that. If you want to stay a while and then leave, whatever you want to do. We just cannot let you deliberate with the other jurors. Does anybody have anything in the jury room they need to get?
All right, so that's just procedural.
Okay. Please let the bailiff know, and they can serve. You don't have to.
Yeah, you guys say you would stay. And this was only 5 days, and not even, because this isn't even a full day 5. Boy, imagine a longer trial. I would stay for the outcome, especially. All right, they're muting us. They might just be figuring out exhibits to send back with the jury. The judge is waiting patiently. And he sounded very sincere, thanking the jurors for their time. Yeah, so they're just going over exhibits, making sure they can send stuff back to the jury. Did they give us a deliberation clock? No deliberation clock, but assuming they started deliberations about here, 2 hours and 35 minutes back. And we come back around like 45, just under 2 hours of deliberations here. So here we go. We are time traveling. I have a banner update on the way. Yeah, factualizes Bev can learn a few things from this judge. Yeah, a lot of judges. You know, potentially criminal says, think of your average judge, and then realize that 49% of judges are worse than that judge. And that's just the law of averages, right? But it's still a crazy thing to conceptualize.
We got the question in from the jury.
Oh, a question.
It says, what classifies as hand of one, hand of all? What are the parameters? Does just being present at the scene of a crime classify as hand of one, hand of all? All I know to do is to just bring them back in and recharge them on the hand of one as the hand of all. And we'll go with that. Let's mark this as
Court's number 3.
3. All right. All right, anything from the state before we bring the jury in?
Nothing from the state, Your Honor.
Anything from the defense?
Your Honor, I'm concerned about this charge. You know, last time you gave me 2 charges that dealt with the agreement. So I can't recall if that's in the hand of one or hand of all, but I believe the required plan or scheme needs to be in your charge. So.
Well, I think it is in there. As I recall, my hand of one is hand of all. mean, this isn't the entire charge, but I think the part you're referencing to,
I believe it's on page 15, Your Honor.
yeah. Yeah, prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or common scheme is necessary for a finding of guilt as a principal. State must prove beyond a reasonable doubt by competent evidence the theory of hand of one is hand of all. And then later on in the charge, present at the commission of a crime. Mere presence at the scene of the crime is not sufficient to convict one as a principal in the theory of aiding and abetting.
Your Honor, I believe the question, it entails the mere presence. I believe that the jury's question entails the mere presence. If they needed further explanation on that, Your Honor, it seems good for me to about that as well.
Well, if that's all they asked, but they asked what were the parameters.
Yes, sir.
They don't lie, and then they went on to say it's mere presence.
Yes, sir, Your Honor.
So, you know, if they had just said it's mere presence, then I would have said,
Yes, sir.
I'm just going to charge them on the entire thing.
Yes, sir. Thank you, Your Honor.
All right, let's bring the jury in.
All right, they're going to bring him in.
All right, ladies and gentlemen, welcome back. I understand the jury had a question on the law regarding the hand of one is the hand of all. So what I'm going to do is recharge you on that issue as it answers, the jury charges answers your questions, and I think will provide the answer you're looking for. If a crime is committed by two or more people who are acting together in committing a crime, the act of one is the act of all. A person who joins with another to commit an unlawful act is criminally responsible for everything done by the other person, which happens as a probable or natural consequence of the acts done in carrying out the common plan and purpose. For example, two people can be guilty of bank robbery when only one of the two enters the bank and takes money from the cashier, while the other acts as a lookout in the getaway car. If two or more people are together, acting together, assisting each other in committing the offense, the act of one is the act of all, or as it is sometimes said, the hand of one is the hand of all. Prior knowledge that a crime is going to be committed without more is not sufficient to make a person guilty of that crime. Mere knowledge that another person is going to commit a crime, even if the defendant is present when the crime is committed, is not sufficient to convict the defendant as a principal. Guilt as a principal is shown by actual or constructive presence at the scene as a result of a prior arrangement. Therefore, a finding of a prior arranged plan or common scheme is necessary for a finding of guilt as a principal. The state must prove beyond a reasonable doubt by competent evidence the theory of the hand of one is the hand of all. A principal in a crime is one who either actually commits the crime or who is present, aiding, abetting, or assisting in committing the crime. When a person doesn't act in the presence of and with the assistance of another, the act is done by both. Where two or more acting with a common plan or intent are present at the commission of a crime, it does not matter who actually commits the crime. All are guilty. The hand of one is the hand of all. Present at the commission of a crime means to be sufficiently near to aid and abet and assist in the commission of the crime. However, mere presence at the scene of a crime is not sufficient to convict one as a principle on the theory of aiding and abetting. Intent is also a necessary element, for there must have been a common design or intent to commit the crime, and the crime must have been committed pursuant thereto, with the person aiding and abetting by some overt act. Intent means intending the result which actually occurs, not accidentally or involuntarily. Intent may be shown by acts and conduct of the defendant and other circumstances from which you may naturally and reasonably infer intent. The state must prove these elements beyond a reasonable doubt. All right, I'm going to ask that you return to the jury room and continue with your deliberations.
Alrighty, so no verdict clock counter. So we're just gonna time travel till when we see activity. Yeah, so they were back for another like 10 minutes after that instruction, that question. And remember, there's two pathways. She did the murder, or, you know, through constructive action, she knew that there was a plan to commit the murder and she was there when the crime took place. Two pathways to find her guilty here. I guess we can move forward quite a bit. I don't want to miss it though, so we'll move a little slowly here. Somebody went away from the courthouse that needs to be present. Oh, all right.
Ladies and gentlemen, I've been informed that the jury has reached a verdict. Anything from the state before we bring the jury in?
Nothing from the state, Your Honor.
Anything from the defense?
Nothing from the defense, Your Honor.
All right, ladies and gentlemen, those of you who are with us, I give this instruction every time before the jury comes in, and that is simply to let you know that we cannot have any type of outburst or anything of that nature, regardless of what the verdict is. This is just simply to let you know that if you're unable to contain your emotions, you need to excuse yourself from the courtroom now. Because regardless of what the verdict is, there's to be no display or no outbursts or any sign of emotion whatsoever. All right, so if you need to be excused, you can go ahead and excuse yourself now. All right, let's go ahead and bring the jury in.
Filled up in the gallery there. I don't know how often lawyers make it on the jury after voir dire, but yeah, presumably they can explain the jury forum and, you know, try to explain from their experience. But ultimately, they shouldn't be instructing anything beyond or outside of what the court has instructed. Like, they shouldn't be in there talking about, if we do this, this could be the minimum and maximum sentencing and blah, blah, blah.
Ladies and gentlemen, welcome back. I understand the jury's reached a verdict, is that correct? All right, and have you written the verdict on the indictment, signed it as the foreperson, and dated it?
Yes.
All right, if you would please hand it to the bailiff.
Yeah, it was under 2 hours, about 2 hours of deliberations.
All right, I'll ask the clerk if she would please publish the verdict.
Indictment number 2021 GS 2601191. The State of South Carolina, County of Horry versus Meagan Marie Jackson as to the charge of murder. We, the jury, by unanimous consent, find this defendant guilty. Signed by foreperson Jeffrey Roberts, dated June 17, 2025. Ladies and gentlemen of the jury, if this is your verdict, please so signify by raising your right hand. Thank you.
I let the record reflect that all jurors raise their right hand. Any opponent of the jury by the defense?
No, sir.
All right. All right, ladies and gentlemen, I want to thank you for your service. That will conclude your duties as jurors in this case and for this term of court. And I want to thank you for your service. I know jury duty is not a fun thing to do, but it is an important thing to do and a vital thing to do. You have a 1-year disqualification from serving as jurors in state circuit court. You've got a 3-year exemption. I hope you don't exercise your exemption because we do need good jurors. And I want to thank you for your service. You're free to go at this time if you want to go. If you want to stay until the conclusion of the proceedings, you can do that as well. Just remain in the
We have
jury
some
box.
tiers,
It's up to
or
you.
a tier.
Those of you who wish to go ahead and leave now, you can leave now. Thank you very much. All right, anything before we impose sentence?
No, Your Honor.
Well, first, I guess at this point in time, I know the rules of criminal procedure do allow time period for post-trial motions. Is there any post-trial motions at this time?
Your Honor, we move for a judgment NOV by you based on the adequacy of the
A JNOV or judgment NOV, that's a judgment notwithstanding the verdict, I think is what it stands for. So basically you're going to ask the judge that even though we have this verdict in, we're going to ask you to make a judgment either as an issue, a matter of law, or some other like major issue outside of the fact finding. So I don't think the judge is going to grant this, but
evidence presented, and also that you impose a verdict as 13th juror. Having sat through the trial, heard the evidence, we make those two motions. But we would like a little time to flesh those out if possible.
All right, well, I'm going to deny both motions for judgment NOV, and also the motion as the 13th juror. I think there's sufficient evidence presented to the jury that supports their verdict. As I said, the rules of criminal procedure do give you time periods to file post-trial motions, so I'll entertain any other post-trial motions you want to do pursuant to those rules. I'll give you that time. All right, anything further at this time?
Your Honor, we are printing the sentencing sheet. We do have 2 victims who would like to address the court. Savannah Rice, who has been present the whole time, and then Zachary Rice, who is the victim's son from another relationship. With the court's permission, that would be via WebEx because he's had help.
No, I'm not doing WebEx.
Okay.
All right, so once we get the sentencing sheet, I will give the victims who are present an opportunity to speak with their litigation.
I believe Ms. Rice wants me to read her statement.
Well, I mean, we're not doing that right now.
No, I
I need
know.
the sentencing sheet. I'll let you know when I want to hear from the victims.
She just went back to records to get it, Your Honor.
All right.
oof, reality setting in.
Zachary Rice. Your Honor, I believe that Zachary
Yeah,
Rice
guilty
is
verdict.
Emailing a statement that he must have already had prepared. So with the court's permission, I'll read that one as well. He's a statutory victim, Your Honor.
Yeah, but why isn't he here? He has the right to be here, but he's not here.
Because he was forced to take custody of the children when their father was killed, and he has had to struggle to find jobs to now all of a sudden care for extra children.
All right, anything in litigation from the defense?
Now, we asked she be given credit for the time that she was in jail off of her sentence and credit for home detention. I don't have the exact figure, but I'd like to present that to you in our strong motion.
All right. Ms. Jackson, anything you want to say, or does anybody want to speak on your behalf?
Your Honor, she wishes not to speak.
All right. Any prior record?
No, Your Honor.
All right, I'll hear from victims this time.
And Your Honor, did you need me to address the issue of home detention or not?
No, I'm not.
Your Honor, this is from Zachary Rice, who is the older son of Gregory Rice at the time. Once Gregory Rice was killed, Zachary Rice took custody of the 4 half-siblings. And he did this fairly quickly since we did not have WebEx available to him. He says 5 lives completely shattered, showed no remorse, waited 5 years for this, just celebrated Father's Day without him again. I would like the maximum in sentencing, took my father's life, and I want her to pay eye for an eye and lose hers. And then, Your Honor, if I can have Ms. Savannah Rice come on. Your Honor, she's understandably emotional. She says, Your Honor, I believe that my opinion for how long she should be sentenced does not reflect what has already been done. This crime has torn apart my family, others' families, and friends beyond any measure. My siblings and I have all suffered greatly, not only from the loss of my father, but the loss of a mother too, the loss of our lives. We have been waiting so many years for just a bit of closure, and this is it. We will never have the chance to freely live our lives without the thoughts of what has been done following behind us. It has become a challenge to rebuild and grow from everything that happened. There are still days where I just cry and wish I could go back in time to maybe prevent what happened. I can't do that though, and I will forever have the thought that I can't change anything alongside me. This trial and getting up on the stand has been one of the most heartbreaking and painful things I've ever had to do. It has also been one of the most relieving and rewarding things. I finally got to say what has been sitting in my brain the last 4.5 years. It was a relief finally being able to tell the truth and to go towards a cause. I believe that 50 years to life would be a sufficient amount of time. I thank you for your time, for listening to what I had to say. Thank you. Does Your Honor wish the state to address sentencing?
Well, if there's anything you want to put on the record.
Your Honor, the state is asking for the maximum term of life imprisonment. We believe that there is clear evidence that this defendant not only plotted and planned this murder, but also tried to frame the victim for things that she was doing. As Savannah said, and as I said in explaining why Zach couldn't be here, this really did destroy a number of lives. Zach was forced to take in 4 children, his half-siblings, as a result of them being EPC'd after Meagan Jackson was arrested. We believe that there was nothing short of life in prison that would address this crime.
All right, Ms. Jackson, you have been found guilty of murder by a jury of your peers. The sentence of the court, I agree with the state. The sentence of the court is that you be committed to the Department of Corrections for the remainder of your life. You'll be
Life.
free for any time, sir. All right.
Thank you, Your Honor.
Thank you.
There you go.
All right, anything further from the state?
Nothing from the state, Your Honor.
All right, court is adjourned. Thank you very much.
Thank you, Your Honor.
I don't believe she was offered a deal. I haven't seen any reporting, trying to look back. And of course, when you try to look back without doing an extensive search, I might be missing articles that could have said as much. But based on Christopher Dontell, the co-conspirator and ex-lover, ex-coroner, the day of his trial, after voir dire for his jury, he stood up right before trial gavel was about to go and said, I want to plead to accessory after the fact. He ended up taking a plea for accessory and the conspiracy, and his sentencing is withheld. So we'll also have to see what happens with Christopher Dontell's sentencing. I don't believe that that's something that they'll just erupt and announce today, because they have to get him into court and schedule that. So that's something that will be a short update in the future. Oh, Savannah. Savannah, so if you missed the beginning of the trial, Savannah is the daughter that took the stand. That's who we heard she wanted to get the truth. Everything that's been in her brain, she wanted to get it out. She's the oldest sibling. So it seems like she bared a lot of responsibility leading up to all of this chaos, and then the aftermath of it. As the older sibling, who now her siblings no longer have a father, and in due time, Mom, for better or for worse, was taken into custody. So I think this is justice for Gregory Rice. That's my opinion from what I saw presented at trial here. It doesn't really matter to me whether the judge thought she was an accomplice or actually did it. I personally think she's the one that pulled the trigger. And I believe there's a good chance that Christopher Dontell was shocked and surprised in the moment while he was driving the vehicle that someone, all of a sudden, shots are going off. I think that's entirely possible. Is it the only option? No. But I believe it for what it's worth. You see, I updated my banner. Peter Ortiz has been waiting for this moment. We have a dancing hippo that says victory. So I didn't want to harp on this until we got to the verdict after our time traveling here. But Peter Ortiz, thank you so much for the super sticker. Thank you so much for your patience with the spoilers. I think the sticker was well earned, a little hint of what was to come. I think this is, there's never justice when someone's life is taken. The kids don't have a father, now they don't have a mother. But as far as the limits of justice can go, I mean, life without parole, there you go. I was not all that impressed with the defense attorneys, but they did hit the little procedural marks, right? They did raise legal issues quickly. The father did, especially, but his cross-examination of the star witness, I think, was a whole waffle. I don't think the dad was very good with cross-examination. And kudos to the prosecution. I don't think that there were anything that... We had the awkward question from one of the witnesses, Detective Skillett, Investigator Skellett, where the defense attorney asks, was there a crime scene? And he was stumped. And he's like, at that time? No, anytime was there a crime scene. And he's just like... And, that's not the greatest look. I get that he probably thought it was a trick question, and that's why he was stumped and hesitating. Probably not a great look for an investigator or officer to not know if there was a crime scene in the middle of a murder trial. But besides that, I don't see misconduct or Brady violations. I think the biggest reach was right in opening, where the prosecution wanted to introduce photos of guns that had no tie to the crime. They don't fire the same caliber, they're not the right make and model, there's no forensic evidence tying them to what's being alleged, and the judge correctly ruled that inadmissible, because it'd be more prejudicial than probative. Yeah, Derek says that was the worst cross I'd ever seen. I'm not kidding, you guys. I clipped it out separately. I think it was day 3. Day 3 if you want to watch the whole day. But Christopher Dontell, when he first got on the stand, there's maybe he's trying to get out of extra time by making it seem like he had no idea of the murder and pinning the murder on her. There was some wiggle room there to work with. A bit more difficult with the accomplice liability at play, but still a little bit of wiggle room that the defense could have worked with. Maybe if she was actually pregnant and she thought it was a different man and he got upset and thought it was Greg and killed Greg because he thought the baby was Greg's and she was cheating with Greg. There was room there to get into something, and the defense just didn't even go there. So, but at the same time, I think Ms. D, defense didn't have a chance. I think the facts were just bad. So this was an easy case for the prosecution to get right. Maybe, although I have criticisms of the defense attorney's style and kind of lack of effort maybe on the cross-examination. I just don't know how to describe that. At the same time, if the facts are bad, there's only so much, you know, imagine a Brian Steele in here. We'd get, you know, the conspiracy. Who are the two people that conspired? That's an issue. Well, these defense attorneys hit that mark. Would Brian Steele have made Meagan Jackson look any more sympathetic? And I don't know, but I'd say the facts, probably not so. Probably not so. What's next? So I don't know about what's next specifically. Do we have a... Let me double check and make sure there's no verdict updates or anything like that from Kathy for Karen Reed. Nope, no updates there. And the day's approaching the end over here on the East Coast. Plans and Pens mentioned... Let me get the name of the case. It's a Fulton County case. Who was doing it? Maybe 11 Alive? Let's see. I don't want to just give the I want to get the name of the case. And we'll get some context from Plans and Pens once I get the name. Okay. Nope, that's not it. Atlanta News First, maybe? Yes, okay. So, and this looks like it might be closing arguments. So I'm going to recommend this. We're not going to redo the whole trial. But you can tell just by the look of the court, we're in Fulton County, very familiar paneling and lighting. I see Candace is over here hanging out. So this trial, let's get the context. Prosecutors are arguing Rodney McWay mistreated his 3 children and intentionally deprived them of food and water. Police found McWay's daughter, 4-year-old Treasure, unresponsive during Christmas of 2023. She, along with her 2 brothers, was taken to the hospital for treatment, where Treasure later died. McWay's attorney is arguing he never intended to harm his children. So Plans and Pens gave some additional context, and this is a sad case, right? Whatever the situation is, this is tough subject matter. Plans and Pens had taken the time to give us some context. I just got to find it. Let's see. All right, so let's see. It was only... She said, have you been following the case in Fulton of the father who starved his daughter and caused her death? They are doing closing arguments today, too. That's what's going on now. The police and DCFS, maybe Department of Children's Something Services, really messed up with the investigation, and they got slaps on the wrist. So, and we'll have to see the outcome, but imagine an injustice was done to at least one kid, and just the pathway to justice is messed up because the arms of the state can't just follow processes and procedures. So Plans and Pens says it was about 6 and 7 days. So I'll link to this in the chat. This is the starving trial. Yeah, and lots of news articles about it and the investigation into APD and DCFS's response, or rather lack of response, to calls for help for the kids. So there were calls to help being made, and that was being ignored. So this is another one, right? You know, and I don't think I'll stream to go over this case working backwards. You guys can watch it here, but this is something I'm going to put on and try to tune into, see what the jury was presented with. Because just think about what can go wrong the next time something like this happens. If, Plans and Pen says they just got a slap on the wrist for doing things wrong. Well, what does that mean for the public moving forward? It's not very reassuring. So there's that linked in the chat there. Okay, and Candace says he refused help. So dad refused help when someone did respond. And that's always interesting because I hear anecdotal stories from people that, spiteful parental co-parenting drama where someone, or even like different familial relationships, like grandparents versus parents, where the parent isn't letting grandparents see grandchildren, where they just try to make a frivolous call to CPS to, just to spite or, stir something up. But even though it's frivolous, CPS will barge in there and make sure everything's okay. At least that's what I've seen in my anecdotal experience. So to hear on the surface here that somebody gets a report and somebody shows up and the parent just saying, no, I'm refusing. Typically, I hear stories where it's more invasive than is actually warranted, but they take the precaution and they choose it. Procedurally, they're invasive to make sure there is no imminent harm or conditions that could gravely affect somebody that's in somebody else's care. So here, why isn't that invasiveness? Why are we missing that invasiveness here when it could have made a difference, right? Where's the balance? So, oh no, and Candace is saying good luck with the camera. That camera person was not good at all. So those are the things you've got to prepare for. So just crazy, just crazy. Huge shout out again to Peter Ortiz for the victory sticker here with the verdict relating to the verdict in the Meagan Jackson trial. She's done. She's cooked. Life without parole. That's that. That's a wrap. Sentencing on Christopher Dontell will update when we see some news on that. STS dropping another 5 gifted subs. So I updated the banner. We didn't get any water pours in the courtroom today. But STS has been super generous gifting the memberships. Make sure you guys are saying thank you. And little do you know, I love doing these trial watches. I'm still running trials in the background to watch as, whenever I'm busy with work, I'm still paying attention to what I can. But I just yesterday accepted a CEO position for one of my clients. So I'm officially not a client anymore. The company is not profitable at this time. Very optimistic, but until we get there, you guys have seriously supported this journey with what I'm doing over in the real estate space to bring transparency to real estate transactions. So, like, when I say I'm grateful for you guys coming and spending time, you guys give me peace from work, right? And I get to do what I enjoy. But when someone is so generous to support the channel, you guys are supporting something else I'm doing in the background while, basically taking January till now to build up this company. And I think it's finally going to turn green, and I'm really excited about it and what I can do with that. But that wouldn't be possible. I wouldn't be in the same position without you guys over here on this side of my world. So big thank you here. Especially STS, Peter Ortiz, Taybiz TV, just like dropping in these gifts. Taybiz dropped in another 10, and he's a creator himself. So he knows what it's like. You got to pay for these StreamYard kerfuffles and then restream whatever's going on. But, Taybiz is doing it because he's passionate about this stuff. Coming over here and supporting me, which is just incredible. Like a week or two ago, I was at my wit's end with the structure of, decisions weren't getting made with this company. And he just sent a random, thinking of you. And he didn't know I was going through it with work. But it was just so supportive. And it made all the difference. So huge thank you here from Taybiz giving the 10 gifted subs. I want to say today, but it's tomorrow. He will be live. You guys are looking for other stuff to talk about. The Mickey Steins shooting the judge is just going to be a crazy thing to watch. I mean, think about how debilitating it's got to be for, a sheriff who's in charge of training all his downline personnel, shooting a judge. We're trying to figure out what went wrong, and it's a smaller town. that shooting, I feel like, cannot be isolated to just this one person shot this other person. There's got to be something that trickles through the court system, the sheriff's department. It's not just in a vacuum. So Tabiz has been doing a deep dive. It got a good amount of coverage when the story first happened, but I'm really not seeing much coverage now as we approach potential trial dates. So tomorrow he's going live at 6:45, but I'm going to link you to part 1 of the deposition reading. And his voice is so easy to listen to. But I highly, highly recommend check out the Mickey Steins story. Crazy case, and obviously you've got it's the arm of the state, sheriff's office, and the judiciary, a judge. So what is going on? All right, so here is the part 1 to get you guys started. And thank you, Factual Lie, for dropping the link just to Tabiz's channel. Make sure you hit the bell because YouTube's funky bunch about that stuff. Thank you for the congrats in the chat, you guys. Hey to not a honeypot. Good to see you. You came right in here at the end. Am I going to cover the Coburg trial? You know, I've really been watching Andrea Burkhart's coverage of that. You know, because she went down to the court in person. I don't know if she's going to plan to do the same thing. But I really like her insights. So, I don't know. I might do something with recaps on that because I think that's such a divisive case. And I don't know where I'm going to land when I see what evidence is presented. But I think it's a huge issue that there were things being reported in the media that the information, in my opinion, only could have come from the prosecution. And then that evidence, that proof, that information isn't actually there. That seems to me to be like spoon feeding from the prosecution to the news, possibly tainting a jury pool. And the defense successfully motioned for a change of venue, but they had to do real statistical analysis to prove their case. They went out and were surveying people, which I'm sure wasn't free to do. And it can't just be like, we asked somebody and they said they heard about this case. They have to demonstrate a methodology. And they were able to do so successfully and get the trial moved to a different county. Is that going to be enough when it's nationwide coverage? I don't know, but seems like they're moving forward. Yeah, I think I might have like either as trial approaches. I know Andrew's done a ton of coverage of motions in the Koberger case. Excited utterance or Hella also. But I think that's one where I'm going to have gripes where it's kind of like, if this case is so cut and dry and so simple, the prosecution shouldn't be overreaching and dipping their toes in water across the line just to get their argument, their case to the finish line, to a conviction. Right? Don't play games. If you have a win, just win the game and play fair. So that might be a pet peeve case of mine, honestly. We'll see how that plays out. And Tabiz says, thank you for the love cat. Of course. I'm glad that you've gotten back into, streaming the trials. I know you have your like collaboration, your podcast that you have with your friends. But I'm glad you're doing trials too, because it's like, it's my hobby. It's what I do to wind down from work is I watch Lawyer's Lawyer. Let's see. Ms. D says, then I heard it's an Uber driver going to testify that they'd seen him. Yeah, so, I mean, all of that's up in the air. And I'm with you, Ms. D. I honestly don't see it being a clean case. And certain things being murky, the public's going to talk, the news is going to cover what they think they can cover. And that doesn't necessarily mean that just because there's media coverage and the media gets something wrong, that there's something nefarious going on behind the scenes with the district attorney, the prosecution's team. But if it gets to that point where it seems like the prosecution's trying to win the court of public opinion, instead of just proving their case in court, I find that problematic. I don't think the prosecution has the right to a public defense in the media the same way that a defendant might. So, but that's just my opinion in general. It's not really specific to the Koberger case at this moment, but it is raising an eyebrow. Same thing, you guys know me with Courtney Clenny. I don't think Courtney Clenny is going to be able to convince a jury that she was justified in killing Christian Novumselli. But the prosecution is just moving so stupidly. So stupidly. And it's like, why? And then at the final hours, right before it, all signs are pointing to the lead prosecutor being ordered to sit for a deposition, he voluntarily steps down. Well, that's just kind of like you trying to make yourself look good when you know you're off-ramped anyway. So you're taking advantage of the off-ramp that you're being forced to go down. Instead of just, hey, something's amiss here, let me off-ramp myself when it was appropriate months ago for me to do so. And now we have someone that had multi-millions in wealth, selling her property where it seems like that was the store of her wealth. She's got money and she's still selling her home where she stored her wealth to pay for her defense going on for 2-3 years now. How is a regular person with a regular, income supposed to navigate a system like that if Courtney Clenny, an OnlyFans model that made several million, can't do it? So sometimes the things that are the best for all might make it for us where we're in a position where we have to fight and call it out when something wrong is done to somebody that maybe we don't like very much. But if we don't speak then, it becomes okay when it happens to someone we do like or do think is innocent. So that's my soapbox. That is my soapbox, you guys. Yeah, slap my slime. I hope you guys, I don't expect us all to agree on the facts of the case, but I hope that part of the reason we all get together is because we just want to see things done the right way, right? We're never going to align 100% on what we think before, during, and after a trial. It could shift throughout the whole journey, but just look for things to be done the right way. I said we were going to take a quick look at this other South Carolina story. And Touche, good to see ya. Touche says, I've been mostly lurking this Meagan Jackson trial, but I think this is justice. I'm in that boat. I'm with you. And not a honeypot. If you need investors, I know you said it's not profitable at that moment, but let me know. I can reach out to a couple of friends to help get you started. Hey, so we actually do have an enterprise program where, when you invest in seats for the real estate agents that list properties on our platform, you get passive income in perpetuity through revenue share. So you don't have to be a licensed agent to get the referral fee because it's coming through revenue share from us rather than from the broker, the listing office. So that's one way for investors. They can actually buy seats and make a downstream of residuals from the agents that are listing on our platform. Once we have that, it's launched and people have bought into it, but we didn't do the front-facing marketing. When I have that, I'll share it with you guys for sure. I think it's a great opportunity. This with Michael Colucci. So this is an older case, you guys. Michael Colucci, this is like when you see the photos from the case, you can tell, oh, this was unsolved for a while. What was going on? This is what's being referred to as the garden hose murder trial. So Michael Colucci, he was facing a murder charge for allegedly murdering his wife, Sarah, in 2015. But while this stream was going on, I saw an update that, judge dismisses this murder case, squashes the indictment. This is without prejudice. So with a new indictment, he could be back in court. So, but what happened? Judge Roger Young has dismissed the case for Michael Colucci's alleged murder of his wife in 2015. The indictment against Colucci has been squashed without prejudice, meaning another retrial won't be possible without a new indictment handed down from a grand jury. Tuesday, Judge Young heard arguments from Colucci's defense team following a motion to dismiss filed several days ago. So the defense argued here, government misconduct. They claimed that South Carolina Attorney General's office had material that detailed Sarah's plan to die by suicide for the last 10 years. The implication here being the government had this information and didn't disclose it to us, but they had it. So the defense argued that Barbara Moore, Sarah Colucci's mother, had told a SLED agent at the time that Sarah had said she would have hung herself if it were not for her family, and that she would never do it because of them. Moore took the stand Tuesday and told the full story. Let me link you to this clip in case you guys want to watch this. We'll call it Moore's testimony. Former prosecutor Meagan Birchstead testified Tuesday morning, saying she was unaware of the story until recently, and that she was floored to find out that Sarah was reportedly potentially suicidal. All right, let's hear that tone of voice.
So you're not aware that David Owen in 2015 knew that Sarah said 2 weeks before she died that she would hang herself in her own garage?
I don't know what he knew, but I certainly never talked to David Owen about that.
Okay, he never told you that?
No. If he had told me that, I would have been shocked, and that's something we would have turned over.
Okay. So obviously you had a conversation with Barbara Moore about that day that she described, Sarah being upset, crying, right?
I must have, yeah.
I mean, of course, you're an
Preparing
attorney.
trial, right.
You're going to prep for trial.
Sure.
And you're going to ask her questions about, well, what did Sarah say? What was going on? Give me all the information you have about that day. You would have asked those questions.
I would assume, yeah.
And she would have told you what she said was, if it wasn't for the girls coming home, I would have hung myself in this garage. She would have told you that.
I do not recall that. The first time I heard that was when Joel Kozak called me last week, and I don't even remember all the details, but I was floored when he called me last week and said that.
Okay.
Panic, 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 panic. That is a big oops. And I assume that they're going to, draft another indictment, take it to the grand jury. And if grand jury found enough evidence the first time around, we'll probably end up back in court. But now the defense has awareness of this conversation. And the wording we got from, I'm assuming that's a defense attorney that was questioning the prosecutor here. The wording made it seem a little different. In this article, it said, she would have hung herself if not for her family and that she would never do it because of them. This kind of makes it seem like she could have had general thoughts and maybe was expressing gratitude for her family. Like, I would have killed myself a long time ago if it wasn't for you guys. But it's a little different to hear that she may have been sitting in the garage in a specific moment. And when someone arrives home, the kids arrive home, she says, yeah, right then and there, I was about to hang myself. If it weren't for the kids coming home. That's a bit more specific than how this article is wording it here. And either way, the information should be disclosed. And we have the prosecutor just saying, well, they didn't tell me, I didn't ask, I didn't know, therefore I couldn't have turned it over to you. But your people still knew, SLED still knew. So still a problem for the government. And remember, this is again, the allegation is that she was unalived with a garden hose. So seems pretty relevant that on a previous occasion, at least one prior occasion, she was sitting in the garage where one might have access to a garden hose about to hang herself, specifically the mechanism of hanging. So I don't know, maybe this one will be interesting to watch as it develops. Yeah. Crazy. And again, I'm not making conclusions on one way or the other, but that's seems like the state, whether SLED's to blame or the prosecution knew and is being less than forthcoming here. No bueno. So Tay-Biz and Factual Lie with the Karen Reed updates, they're going home for the day and they'll be back tomorrow. I think they're hung on that OUI. And that's rough because it seems like they're aware that if they hang on that, she might be able to be retried. I mean, I kind of have a hard time believing that the jurors aren't aware of what happened with the first trial. And that's not really necessarily their fault. They live in the area. It was a big story. And they've had mention of prior hearings, prior testimony. I mean, they're going to put two and two together, at least in some way. But right here with this, the questions, they're hung on this OUI. Would it be hung on the manslaughter charge if we're hung on a lesser included? It seems like at least one person on that jury wants it an acquittal across the board and won't budge. And maybe someone doesn't know. I said at the beginning of this stream, if I was inclined to want to convict on the lesser that she was drinking and driving, it wouldn't sit well with me if I thought she was not guilty of a higher charge. And unanimously, all 12 of us think she's not guilty of that top charge. But by us being hung on a lesser, that legally the Commonwealth would be able to retry her for the top level charge. That might be something I've got to sit with and stew with on my conscience. And I don't think Judge Beverly gave clear-cut guidance or answers on the questions they asked about that issue. So with that being said, court's closed tomorrow, right? Isn't tomorrow a federal... Is court open tomorrow? What date is Juneteenth? So they're not observing. They're going to do that on Friday. There's another case. I don't even know what case that they said no court Thursday. And I wonder why they said no court Thursday. Okay, yeah, so closed Thursday. Oh, tomorrow's Wednesday, not Thursday. Scratch my whole last confusion. I thought tomorrow was Thursday. So that was user error on my part. That was me. I thought tomorrow was Thursday. Oh, chat. Well, thank you so much for hanging out, you guys. You see, I just scrambled my own brain. Thank you for the encouragement with what I've got going on with work. I'm excited to see that come together. Again, I thought this was super cool. We had a property, one of our agents, West Atlanta home. Look at this street name. Whitaker. So I thought that was a really fun overlap. But I will fill you in on what goes on with work and why we're bringing transparency to real estate. You guys know I want transparency in courtrooms. Thank you for clarifying my awareness of what day it is today. Guys, I don't have, there's probably so many. Do you guys want to just go to a Karen Reed stream, even though they're going home for the day? Or where do you guys want to go? What do you guys want to watch? I know there was some crazy weather. I saw, like, there was a huge tornado yesterday. Maybe there's a weather stream. Do you guys want to go over to Andrea Burkhart? I think she started in the middle of this stream, so she might be going over her thoughts for the questions. Yes, Sabata, thanks for making me feel better. Oh, goodness. I really thought today was Wednesday. Yeah, everyone has a verdict. Watch Karen Reed stream. So we'll do Andrea Burkhart over here. Get you over there. Guys, if you're interested in Koberger, make sure you hit the subscribe button for Andrea, even if you're not interested in the Karen Reed trial. She's done great coverage. She's got a ton of content through all the motions, the arguments, the media and press issue. And again, she's gone down to, before the change of venue, she was down in person in the court for some of the hearings. So there's that. We'll redirect over to Andrea Burkhart. See you guys over in that chat. And I will keep you posted on sentencing for Christopher Dontell. You guys take care. Have a good one.